go through the process. And there we go, Julie's just got us going. And obviously if there's matters that you're missed through not being able to hear or otherwise, the Zoom record is available on request for particular parts of the hearing. So with that, I do see quite a few familiar faces. I've got, it looks like about 20 people on the call, maybe, yeah, about that number. So look, I think it's worthwhile with a new week, we'll just go through the list and introduce yourselves so we all know who's who. So maybe starting with you, Keith, if you just acknowledge yourself.
Kia ora, everybody. Keith Holswich, Ngāti Rahiri Hapu. I'm watching brief today. Thank you.
Thank you, Keith. Damien.
Good morning, everybody. Damien Elton. Two roles today. One, working for Marshall Day Acoustics in terms of the Section 42A reports, perhaps this afternoon, and also as a private submission regarding signage in the city centre zone. Thank you.
Great. Okay. Chris Marsh.
Morning, Chris Marsh, Ngāti Rahiri, just listening.
Thank you, Chris. Dean Raymond.
Tēnā koutou katoa, Dean Raymond, planner with Heritage New Zealand. I'm talking to my evidence at some stage this morning.
Sure. Welcome back, Zane. Dean. Zane.
Yeah, kia ora all. Zane Wood from First Gas here.
Welcome, Zane. All right, Geraldine Bowman. Hi, Geraldine.
Kia ora, everybody. I'm largely got a watching brief, but Dean has asked me to attend to support his evidence.
Thank you, Geraldine. Hilary Walker.
Yes, so good morning, everyone. Let me just get my video. So yeah, we're speaking today. I'm the part of the team with Federated Farmers. I'd just like to say at this stage, Commissioners, Mark Hooper is joining us. He knows, I understand we're about fourth on the list today. As you'll appreciate, it is an incredibly busy time on farm at the moment, and Mark is doing what he can to make it certainly before 10. But if not, yeah, we'd certainly appreciate it if maybe the speakers after us or, could jump the queue if that's okay. He certainly expects to be able to be available mid-morning. Yeah, so just thought I'd flag that at this stage.
Okay, that's great. That's no problem, Hilary. Thanks for that update.
Thank you.
Yes, Maria, I can see you there again.
Morena everyone, Maria from Taranaki Iwi. I'm just listening today again.
Kia ora, Maria, welcome back. So Mike Ekdal, I can see you there.
Morena everyone, I'm just here to do a submission on behalf of Ekdal Property Management and representing some tenants and buildings that we manage.
Welcome, thank you, Mike. We'll talk to you a bit later.
Thanks.
Yeah. Dermot.
Kia ora, everybody. Am I visible there? Yes, right, yes. Kia ora, everybody. I'm Dermot. I'm the returning officer for the temporary activities chapter. I considered the submissions on the temporary activities chapter and wrote the Section 42A report. And I believe we're aiming to do the verbal right of replies later on today. Cheers.
Thank you, Dermot. Michael Campbell.
Kia ora, everybody. Michael Campbell here on behalf of Kāinga Ora, and I'm presenting evidence today in relation to the Earthworks section. Thank you very much.
Thank you, Michael. We'll talk later. Ali Gibson.
Morena, everyone. I'm Ali Gibson, and I'm the author of the Section 42A report for signs.
Thank you. All right, Sarah Marco, you're next on my screen.
Kia ora anō, Sarah Mako, Tēku Teitanga o Te Atiawa, just listening today.
Okay, thanks, Sarah. Kath, I can see you there.
Kia ora koutou. I am Kath Hepplethwaite, planning consultant. I'll be presenting evidence for Wākakatahi later today.
Yes, talk to you later, Kath. Thank you. Alan C.
Good morning, everybody. I'm Alan Catchpole. I'm a planner with the Transport Agency. I'm obviously having trouble with the technology.
Yes.
I'm sitting in with Kath Hepplethwaite.
Great. Thank you, Alan Catchpole, and nice to see you again after quite a few years.
Indeed, Mr. Chairman, yes.
Okay, thank you. Casey.
Morena koutou. Casey Bellamy from Tēku Teitanga o Te Atiawa, just listening in today.
Thank you. Gerv, you're next, I think.
Kia ora, Gerv Singh, Kainga Ora. Thank you.
Welcome, Gerv. And Nicola Lawrenson.
Morena, everybody. I'm the 42A author for the Earthworks report. I'm looking forward to listening to all the evidence today.
Okay. Right. I think that's everybody that I can see. Yes. Thank you. And look, just to start today, there are a few procedural matters that Kit and I would like to go through, but I understand Sarah Edwards is away getting a COVID shot this morning, so she'll be around later on. Just for the council team, for a couple of reasons, we are going to suggest we defer your reply back today and find some time later on in the hearing. The hearing is actually scheduled to go through till Thursday, and just the first reason really is to give you a bit more time to hear the evidence today and to provide that in your verbal right of reply, any responses you'd like to cover. The second reason is we, as Commissioner Littlejohn signalled on day one, we are still a little troubled as a panel with some of the way the plan is structured around matters of discretion, assessment criteria, and how policies sort of may or may not relate into either matters of discretion or assessment criteria, and the use of the term effects criteria and how that all sort of hangs together in the big picture. So we're talking as a panel on that tomorrow afternoon because the other commissioners have not really been available to focus on the matters that Commissioner Littlejohn raised on day one. We're doing that tomorrow afternoon, so we'll be asking that we do have a special right of reply session probably on Wednesday afternoon, if that might suit everyone, and I'll leave you, Julie, to think about that on both the two distinct components. Firstly, the verbal right of reply from each of the Section 42A reporting officers relating to the 5 subtopics in hearing 4. And secondly, a discussion with Sarah and perhaps some of the others on the team about the structural issue around the wording of the plan as how it relates to those matters I referred to. So we can confirm that with Sarah when she comes back online, but that's just to give you a heads up of what we're thinking. Any questions relating to my introduction? Right, I'm just getting up the hearing schedule on my system. And Julie, while I do that, can you just remind me who's up first?
Thank you. You've got Dean Raymond and Heritage New Zealand.
Okay, that's right. Welcome, Dean. Can you just turn on your mic and we'll kick off with you. Thank you.
Tēnā koutou katoa. Mihi aho ki tangata whenua o Taranaki, and greetings to hearing panel and everyone. Firstly, can you hear me clearly enough?
Yes, you're good. Thank you, Dean.
That's good. So just starting off, I have not prepared an extra statement. My evidence is fairly brief in itself. So I'm just going to just comment on a few aspects of it, and then obviously there may be questions. So I'm just going through my statement of evidence down to paragraph 12 and 13. My comment is that the Earthworks rules should refer to...
Just hold for a moment.
Yep, sure.
Dean, we've got paper for Africa here. I've had everything printed off prior to the hearing, and my comments and notes all over those. So I'm juggling between about 4 or 5 different folders. So if you see Commissioner Littlejohn and I ducking around, it's not because we're not focusing. We're just trying to keep up with the paper in front of us. So yeah, I've got your statement now. Thank you, Dean.
Yeah, okay. So I'm just skipping down to my paragraphs 12 and 13. And my comments there are related to Earthworks rules should relate to both SASM and historic heritage as a whole. As they read at the moment, it talks about archaeological sites, and it actually reads Māori historic heritage. So I've got a suggested amendment there on paragraph 13. So just a comment around, obviously, I think everyone knows that Māori historic heritage, archaeological sites of significance, whether discovered or not discovered, not rediscovered yet, are very sensitive to Earthworks. These comments in my paragraphs there relate to historic heritage in general is also sensitive to Earthworks, potentially. The district plan does include provisions around things like new buildings on the site of a heritage item, subdivision of a site. And so this just also relates in a similar way to the setting and the surrounds of heritage places. So that's just a comment on that point there. I just want to go down to my paragraph 17. I stated that there is no reference to Earthworks in the historic heritage chapter that's equivalent to SASM P4. That's actually not correct, because there are equivalent provisions, particularly in the historic heritage chapter, that relate explicitly to archaeology. And they read very much in parallel. So the point
Mr.
of this
Raymond,
is...
would you like to change your evidence? You could read, we could cross that out, and you could read us in some additional words. So you're changing your evidence there, is that right?
Yeah, in 17, yes.
Okay. So how would you like us to write down your evidence on those matters?
I would say that Historic Heritage Policy 15, it's HHP 15, is directly equivalent to SASM P4.
Thank you. And cross out.
Cross out the first sentence.
Earthworks.
Yeah.
Thank you.
So this overall relates to the discussion around whether the Earthworks Policy 4 should remain or be deleted or be amended or be moved to a different chapter. And I have been listening to the evidence of Keith, Maria, and Tatiawa. So I've been aware of some of those discussions that happened last week, which is very interesting. I just want to highlight that as one of the potential issues we've got. In my opinion, that Earthworks P4 has stronger wording compared to some of the other policies. It talks about avoiding adverse effects and not just managing effects. So words like policies like, which one is it? SASM P4 talks about managing effects. There is also SASM P2 talks about protection, but it's rather in general terms. There's less specific reference to earthworks in the SASM and the HH chapters. So my statement really is that there should be something explicitly around the potential effects of earthworks on these sensitive sites. Where that's located in a plan, I think there's room for movement as long as there's a logic, and for a plan user, it's easy to find. If a plan user has a development in an area which is doesn't have an identified site, then I think it's good to have something in the earthworks chapter that flags this potential issue. So that's why I think it's good to keep a form of policy in the earthworks chapter which relates to these matters. So yeah, I just think that it needs, that there is room for movement, but it needs to be consistent and logical flow, obviously, of objectives, policies, rules, etc. So I just want to move on towards the accidental discovery protocol, which is standard 5. Now I have suggested that it stays, but with some amendments. So at the very end of my evidence, I've got a version of EWS 5 with some red mark underlined additions. And I know there was a suggestion from Commissioner Littlejohn about potentially other amendments. And I think he mentioned, was it 3A, wait for inspection of the site by relevant authority, agency, or iwi authority, or whatever the word might be for that. That would also be, in my opinion, that would be appropriate to add that. So ADP really comes down to 2 aspects. One is managing the legal requirements that come under the Heritage New Zealand Māori Tonga Act. And that needs to be consistent, but within that overall consistent framework, there needs to be room for the tikanga, which comes in, and it may differ from the different hapu and iwi. It may differ from even site to site, depending on what the actual place is and the significance of it. But under the recommencement of work section, going down to the last paragraph of that, there is space for appropriate tikanga to be followed with the sites of Māori origin. Maybe there is scope within that section for amending the words to make the discretion within that section broader. At the moment, it talks about where there's koiwi and where there's revisions to the planned works. So it's a bit limited in scope what the tikanga relates to. So perhaps I haven't got suggested wording for that, but that's an area that may be appropriate to broaden out a little bit. So that's really all the comments I have. Regarding signage, the signs chapter, overall, what I've stated in evidence is pretty much in agreement with the section 42A writer. So I think I don't need to add anything to that. So happy to take any questions.
Thank you very much, Mr. Raymond. And look, I'd like to thank you for sitting in on the previous hearings of the matters from the tangata whenua submitters, because certainly when we were speaking to Ms. Mako, Ms. Hokopaura and Mr. Manu, you would have gleaned that they are concerned obviously about Earthworks 4 and also the accidental discovery protocol in terms of tikanga. And this is an area that, as you said, Commissioner Littlejohn suggested, the reporting officers could look at some of the other matters that he described in S5, for example. So your opinion is very valued. I would like to ask you some questions about your paragraphs 18 through to 23. And I think this is the area that you have focused on in terms of those two key matters, EWP4 and EWS5. So as I understand, you are supportive of retaining EWP4
Yes.
in the round?
Yes.
And is your evidence that it needs to be, after listening to the other evidence and Commissioner Littlejohn, it needs to be somewhat amended from its current form?
I don't, as it stands, if it's taken within the context of the Earthworks chapter, in my opinion, it can stay as it is. I think the issue comes in terms of overlap with the similar policies in the other chapters.
Right.
Yeah. So I don't, and obviously that's not going to be discussed until some time from here, 6 months away or something like that.
Yes, so we are hearing those matters in the new year.
Yes.
But there are some linkages clearly between, when it relates to historic heritage and sites of significance to Maori, there are some clear overlaps, and that's why we've heard reasonably fulsome evidence from the tangata whenua experts in this particular chapter.
Yeah.
So I'd like to just ask you some questions about some of these words that we are focusing on. Your evidence is you like the wording in EWP4 because it includes the avoiding, remedy or mitigating adverse effects rider.
Yeah. Yeah.
Whereas the other two chapters have policies that talk about managing. So you would prefer, my take of your evidence in this regard is you would prefer EWP4 to stay largely unchanged, but in later chapters, when we look at those, to increase the effectiveness of those other chapters, specifically on sites that are scheduled in the plan.
Yeah, so basically, if I look at the other chapters, there are policies there that talk about protect in the SASM chapter, P2, it talks about protecting. It's not explicit regarding earthworks, it's more of a general statement. And it almost, to me, almost reads like an objective. The objective is to, even though it's written as policy, is to protect. And then how are sites protected? They're protected in part by avoiding adverse effects or mitigating the effects. So it's, to me, the SASM P2 fits in that way. It's less explicit. The place where earthworks is mentioned in both HH and SASM chapters, it talks about managing earthworks. So there's sort of a gap in those chapters. On one hand, it's talking about protecting sites, and then it's talking about managing. So managing, to me, doesn't actually mean you're aiming to protect. It's just management could be almost anything.
Okay. Yes. So I think that's clear to me. All right. I do want to ask you about the word "to the extent practicable," which relates to a submission that you don't support. So again, generally, you don't like those sorts of qualifiers where it becomes to a protection type regime.
Yes, the policy already talks about avoiding, and where that's not possible, then mitigate the effects. So I think it's not necessary to have "to the extent practicable," because you've already got that word "possible" in there. And in practice, it's going to come down to, is it possible to completely protect this? If not, what can we do to manage and to mitigate the adverse effects? I think it's an unnecessary addition, which just gives a way out to lessen the protection of these sites.
Yes, thank you for that. Now, in relation to your paragraph 21, this is where you, I think 22 and 23, this is a relationship, this is the Accidental Discovery Protocol, which is EWS 5. And you talk here about the relationship of the HNZPT and the district plan. Now, this is obviously core business for you in terms of your experience. Is your experience that around New Zealand generally, the relationship and understanding between those two acts is well understood by practitioners?
No, I think in general, it's often, it's a confusing area. And district plans have various ways of dealing with this, and some places have nearly all or even all archaeological sites in a schedule in a district plan, and others have none, others have an alert layer. So there's various ways of managing that potential overlap. I think obviously both the archaeological authority process and the district plan has a role, and they're not the same, because obviously the ADP applies to to all sites, whether they're known or scheduled or not discovered yet, not even rediscovered. So it's not it is an area of confusion in a lot of places.
Is there a gold standard, do you think, where a district plan deals with this really well from your experience?
I'm still searching for the gold standard. I've been, looking at a number of plans. In my role, I cover, we call it Central Region. So it's from Taranaki, Hawke's Bay down, including Nelson Marlborough. So it's quite a large area. And there's a number of district plans going through different processes. I haven't actually found one which is gold standard or perfect yet. So it's a matter of, I think it's still under development in terms of what is best practice in this area.
But isn't it true that the Act you work under has been in place since 2014? So it's a long work in progress.
Yeah, I acknowledge that. Yeah.
Yes. Look, I think you might have heard that in my own practice. I deal with, being in Hawke's Bay, to deal with this issue all of the time about when and if practitioners that might require something in a district plan requirement should be looking at the Heritage New Zealand Puhiri Tonga Act in terms of authorisations as well. And I think it is clear enough where there are scheduled sites in the plans, it's this grey area where there may be, just because of the character, location, affiliation of the site to other known archaeology, that there is a reasonable chance that if the earthworks are undertaken, there may be material discovered or rediscovered, as we're hearing.
Yes,
sorry.
If I just add to that, obviously the NZPTA deals with archaeology, it deals with physical evidence of archaeology, whereas there may be sites of significance to Māori which are the intangibles. That's extremely important, but the Heritage Act doesn't cover that. Of course, there is huge overlap between these areas. I think I said there's not really a gold standard, but my preference from what I read of different plans is where sites are known, where the attributes and the values of a site are known, and where they are significant in terms of archaeology, then they are worthy of inclusion in a schedule and subject to district plan rules. Every other site that we might not know much about, or it may, if you look at the Archaeology Association database, it's very broad. It comes down to, includes some things such as a find spot. A find spot's not necessarily an archaeological site, it's just where a thing has been found. So I think if things are included in the district plan, then it's helpful to know what they are, why they're protected, and to understand what the rules are around that.
Right. But back to the grey area of areas surrounding that may have a, on an opinion basis, whether it comes from the tangata whenua themselves or from archaeologists, that although the site might not be scheduled because there's no physical evidence, there is other information, evidence about the fact that it's a past area of occupation, or it's in that grey area, isn't it, that the difficulties often arise?
Yeah.
Yes.
Yes.
And I have been involved in projects where what I'll call cautionary archaeological authorities are sought as a general authority, just to set up a process where someone's working or doing earthworks in and around an area that is in that grey area, let's call it that. Does your Act allow that through its provisions for like a precautionary archaeological authority of any of
So within the organisation I work in, there are archaeologists who work in these areas every day, and also legal advisors within our team. As a planner, my work is the archaeological authority process is not central to what I'm doing. So my experience in it personally is a little bit limited.
Okay.
So I know there are various aspects of archaeological authorities, and if you're dealing with a project, then it may be common to have an archaeological assessment before work starts, so that it can be determined about what are the potential of archaeology there, and that assessment may conclude you need an authority before you start work, or maybe even some areas of the project site you don't need an authority, and you may just have an ADP to cover any unexpected finds.
Okay. Ms. Bowman, if you're there, you could perhaps come in here if you'd like. I am familiar with project archaeologists, particularly on large land development projects, that there are some sites identified in plans and in the archaeological register that cover a much broader area than that. And the archaeologists quite often recommend that there's a sort of a precautionary, more general authority that sets out a process with both HPT and also with local tangata whenua about what happens in this broader area if something's discovered or rediscovered. But I just wanted to understand and get from the Historic Places Trust their sort of views on the legal what way that might be done, or if it is done.
Thank you, Commissioner. Yes, you are correct. Precautionary authorities, we don't like to call them precautionary, we just call them authorities in the sense, and they're based on an assessment by the owner usually, often in conjunction with the tangata whenua, whether there is the probability or potentiality of archaeological material being uncovered during the works. They're favoured often by developers because it takes away the risk of the project having to be halted for quite a months if something is found and then the archaeological process has to be gone through. So if you want to be a bit cynical about it, it is a risk management tool that developers use. We cannot require under our Act anybody to get an authority, but the stick behind our back is prosecution. Apart from also holding them up, having to go through the process, which it does delay, and that's time and money. But it is certainly our policy to encourage anybody who are doing earthworks, and it's usually earthworks we're talking about, to consider very carefully the potentiality and through an archaeological assessment. And that assessment, it usually is done by an archaeologist, often with a cultural element in it that's sometimes done by tangata whenua. And in that assessment, the historical use of the site is often canvassed. So it's as good as our Act allows, and but it's definitely our policy to encourage that. And if somebody asks for an authority, technically, we have to go through the process of assessing it and deciding whether one will be given. We can't say, no, we don't think the risk is high enough, go away. We have to process that application. Does that answer what you wanted, Commissioner?
Yes. And look, I'm particularly interested in just the relationship of Section 46 of your HNZ PT Act when information is put forward for an authority. I think I talked about this with some of the other submitters last week, that there is a requirement to look at the cultural values aspects and certainly make a statement if there's been any consultation with tangata whenua. And if it hasn't been, there's been no consultation, perhaps why that hasn't occurred. So Section 46, which is a key information requirement act, as I read it for applications, does have this integration between, I suppose, what I call the science of archaeology and the knowledge of cultural values as two distinct items. Is that how you see it?
Absolutely. Our process is founded on the two sides, the archaeological assessment, which is done by an archaeologist, and then if an application has been contemplated, then a cultural assessment, or it's certainly a comment from tangata whenua as to cultural implications. We then, those two streams join together in our internal process, and if the cultural matters are not clear, we often require, we don't accept the application and require more information to be provided. We do not go to the iwi ourselves. It is for the applicant to do that because we believe the best relationship is between applicant and tangata whenua. But most decisions that are made on archaeological authorities have both components involved in it for our decision makers.
Thank you for that. Ms. Bowman, that's very helpful. Perhaps back to Mr. Raymond. Yeah. So look, that is quite helpful in terms of the relationship. What I'm particularly interested in, and after hearing the evidence from the Tangata Whenua submitters last week, it's how the district plan should properly account for the involvement of Tangata Whenua in these, in what, I'll go back to using the term grey area, these buffer areas around scheduled sites or whatever we may call them. And even in this protocols around scheduled sites, where I've certainly heard that the Tangata Whenua roles in these processes aren't strong enough in their views. Is that what you've heard as well? Is that how you've taken the evidence that you heard to, Mr.
I think in terms of scheduled sites within the SASM chapter, there are quite clear policies about consultation and getting the views of Tangata Whenua. I think it comes down to this ADP in terms of places that aren't in the schedule and that may be rediscovered in a development process. So that's what I was hearing about how the hapu and iwi see their role, and the comments in terms of one size fits all, and how the unique tikanga and protocols which they want to use, how it might fit in something which is written into the district plan. That's what I was hearing the other day as well.
Okay, all right. But is there an equivalent of the accidental discovery protocol EWS5 in the SASM chapter?
It's not an equivalent, that's just in this one place in the district plan.
But that relates to, does this one place, does EWS5 relate to, in your view, both scheduled sites and non-scheduled sites?
EWS5 is permitted activity standard for earthworks. So would that apply if to disturb or destroy a scheduled site, that there'll be a resource consent process according to those rules within that chapter. So it's not a permitted activity. Well, it may under the rules or criteria of the Earthworks chapter could be, but then it wouldn't be under the other chapter. So I don't know if I'm being clear.
Okay, I'm flicking back and forth between these various chapters. Yes. So it may be in there, but it's just, I'm just interested about that in relation to both the form of the ADP, its applications throughout the plan, and its relationship to both scheduled and unscheduled sites.
I think if an ADP is for when you're not expecting to find anything, whereas if a site is scheduled, then it has been identified as a significant area, and most of the sites are also identified as archaeological sites in Schedule 4, I think it is. Therefore, any discovery wouldn't be accidental. So I think the process would be, in terms of the policies and maybe its assessment criteria, the views of Tangata Whenua, any results of any consultation, and maybe there's also, when the site's also an archaeological site, any consultation from Heritage New Zealand. So those sort of matters are included within the policies, I think. I'm just trying to find the exact one I'm talking about.
If I could jump in there, Stephen, I think the answer is that the threshold for permitted earthworks in the SASM chapter is very, very low.
Yes.
Yes.
And so that's why there is not there's no permitted activity standards that apply, because it basically is replacing fence posts and grazing as far as I can see.
Yeah.
So you'd assume that anything beyond that would need a resource consent, and then issues of site management and discovery protocols and consultation with tangata whenua could be built into consent conditions, I would have thought.
Yes. Yes.
Yeah.
Yeah. So that's helpful. And look, just to finish this line of inquiry, Mr. Raymond, if we're talking about the difference between accidental discovery protocol, which is in and about an area that hasn't been scheduled or is known, in the processes around scheduled sites, when a resource consent is required and assumingly authority under the Historic Heritage Act is also required, you'd have ordinarily, wouldn't you, some sort of, let's call it a discovery protocol, how those matters are managed as between your organisation, the local hapu, and the developer. Is that how you see this happening?
Yeah. So if it's a resource, if it's two things are in parallel in that situation. One would be a resource consent, and the other would be the authority. And the authority application, as Mr. Bowman mentioned, always includes consultation with the whenua. So all of those matters feed into the authority, and there's an archaeological assessment, there's an assessment of cultural values, and appropriate protocols built into whatever is maybe approved for the activity on the site.
So is your experience that similar matters, let's call them a discovery protocol, there might be a condition of a consent or a process that's worked into both an authority and a resource consent, often contains the sorts of matters that are in the ADP in terms of process?
Yeah, I believe it would be, maybe Mrs. Bowman can say more, but I think it's similar, but obviously it can be designed to be very site specific, according to what is the nature of a site and the sensitivity of it, etc.
So those would be more bespoke.
Yes, correct.
Yeah. And I think what we're being asked to consider is for the ADP, the area of the accidental discovery protocol, perhaps having more effectiveness if it was also bespoke rather than just a cookie cutter approach as per the standard is currently written.
Yeah.
Yes. So whether Ms. Bowman had any comments about that in terms of the differences between ADP processes and then when you're actually dealing with a scheduled site that's caught up either by a schedule in the district plan or under your act?
I mean, if it is a known site, as far as we or a scheduled site, I'll stick to that. Yes, the two processes should happen by force of law, and what one has to ensure is that there is no inconsistency between the two. But the resource consent deals with more general environmental matters. Ours deals with the detailed day-to-day management of the earthworks on that place. But it also has always imports either a bespoke protocol from the local iwi or hapu, how tikanga is managed on site. And if there isn't a bespoke protocol to hand, we have a default protocol, which we make as a condition of the work, the authority. So there is very detailed and site-specific provision for tikanga to be observed on that site. So And that is where there is an authority in place. What an ADP, I always see it as the absolute safety net in this whole process, where nothing else has cut in, like a scheduled site or a known site or anything like that, and where it's an oh my gosh kind of situation. Look what we're uncovering. And that's where the ADP kicks in. But of course, the area in which we have the problems is if there's no resource consent required and people are doing it as of permitted.
Yes.
And
that's what
exactly.
That's why you have an interest in the district plan interface.
That exactly. And that's where the district plan has to try and help us all out. So, and sometimes resource consents are granted, say where a building's been demolished and nobody has any knowledge that there could have been Maori occupation, and then something is discovered, then we're into an ADP there too. Yeah. The two have to work together, but it's not a perfect science.
Yes, no, we understand that and appreciate that. Whether one of you had any stats around the number of, or the percentage of sites that where authorities are sought that relate to sites of significance to Maori as opposed to other heritage sites?
About 90%. I'm guessing very, very, very high.
Yes.
There's very few sites in New Zealand that are purely Pākehā sites. Some of the building sites, some pre-1900 buildings, but there are some of those, but it's between 80 and 90. We do have statistics somewhere. It does go up and down depending on the amount of new development work that happens in subdivisions and the like. Amount of urban renewal will affect the statistics, but it's very, very high.
That's very helpful. Thank you very much, Ms. Bowman. Look, I do want to conclude with a couple of other questions around this inquiry. Have you had a look at the interim guidance version of strategic objectives, which we issued in a minute number 9, Mr. Raymond?
Yes, I have seen that.
So what I'm particularly interested in is your views in relation to the role you have dealing with both district plans and authorities under your act. It's about the direction in here, TW8, tangata whenua able to exercise kaitiakitanga and actively participate in resource management processes and decision making. TW10, recognise that tangata whenua are the only people who can identify impacts on their relationship with their culture, etc. So what I'm thinking is that both what is your opinion about how those are implemented in the current ADP? Would you support having on the face of SW, the number, EWS5, a specific role in there for tangata whenua, and certainly more enhanced than it currently is as it stands?
I would encourage definitely an enhanced role. It is mentioned there in terms of section 2, inform the relevant parties, and recommencing work. But yeah, I think it could certainly be clearer, the importance and the central role of tangata whenua, to make sure they have the opportunity to actively participate in the process and identify, appropriate tikanga, etc.
Okay. And do you see a problem with that standard having some element of, it's not a word I know, bespokeness?
I think it needs to be, there's a balance. It needs to be clear to all land users what is the expectation, what is the requirement, So if it's left open to interpretation, then I think that's helpful to anyone that's trying to understand what's expected of them.
Okay. All right. And all right. Look, one last question I have is about these areas around about scheduled, let's call them scheduled sites.
Yep.
Have you been following the Environment Court process, Hastings District, where Judge Thompson has, I think, made 2 or 3 decisions now relating to the extent and the district plan rules around and about scheduled
I'm
sites?
sorry, I haven't been reading up on that case.
Okay.
Yeah.
Okay. Are you familiar with any other cases that are dealing with this issue? I know we dealt with it in Christchurch City when we dealt with the independent hearing panel there. That was a big issue for Ngāi actually. Down there, they'd actually mapped the site and then they'd mapped a buffer area, quite a large buffer area in some places around about, which had different sort of triggering rules. Are you aware of any others that?
The New Plymouth scheduled sites have a buffer area, and from memory, there are submissions saying it's too big, should be much reduced, and other submissions saying it should be more.
That's exactly, yeah.
So that'll be an interesting debate when we get to that. No, I'm not really familiar. I think in New Plymouth there's some which are what word do they use? They're actually mapped out and identified. This is the extent, verified. Verified's a word. And others that have not been verified have that buffer area around them.
Okay. Yes, I think in both Christchurch and Hastings, it was about the extent of the area, both the geographic extent, how far that buffer area went, and also the types of activities permitted within those. So perhaps when we get to those parts of the plans, we can talk about that further in relation to where the court's been heading with some of these issues.
And of course, it's better if it can be verified and be precise, because that's better for a landowner or a developer to know, is he in or out. And of course, some areas may not fit neatly within a concentric circle of 50, 200, whatever meters you put on it. It may be beyond that as well. It may be more linear. So it's not ideal having that. But of course, even if you do have a identified, verified buffer, verified extent, there's always potential that there could be something just beyond that boundary.
Of course, yeah. And what we don't know, do we? No. All right, well, thank you. And thank you for persevering. Like, this is an area that, particularly given those strategic directions, I think does need some more thinking, and we'll be taking on board all the evidence we've had, including from you, Mr. Raymond. I will hand over to Kit now and see whether he has some further questions.
There's not much left of the witness, Mr. Chair. I just had one, Mr. Raymond, and thank you for the conciseness of your brief. Your suggestion about the amendment to EWS 5 by including explicit reference to an archaeological authority granted under the Puhere Act. I'm just wondering, other than the Resource Management Act and the Puhere Act, is there any other law of New Zealand that provides authorization in respect of archaeological sites or materials?
Not that I'm aware of, no, not
Okay.
with archaeology.
So we could potentially get rid of the or any other statutory authority, because that's just sort of like, it's sort of like a blanket, really, isn't it? If we've only got the 2 acts that might authorize this sort of work, then do you think it's sufficient just to refer directly to a resource consent or an archaeological authority?
The only thing that I have to confess I'm not 100% sure of is it talks about sensitive material. So, and the note at the bottom of the standard, it lists what sensitive material is, human remains, and protected object under the Protected Objects Act. So I'm not familiar with those other legislation, how that might interact. So,
yeah, that's a good point. I'm not aware of needing an authority under the Protected Objects Act, because I thought that act simply classified ownership and obligations in respect of objects that are found of a certain sensitive nature. So, okay, I just look. The only reason, I mean, I'm not in any way concerned about the addition you've suggested, but if it's not necessary and we're just adding words for blankets and we know exactly what we're talking about, then I sort of tend to being quite explicit about that. But that's something I'll talk about with the chair as to whether we, and obviously get council's view. And look, you'll be pleased to know that was the only real matter I wanted to have a chat to you about, and the conversation you've had with the chair was very helpful. Thank you.
Thank you, Commissioner.
Thank you very much, Mr. Raymond. Well, I think we'll probably see you again. Thank you. All right, Julie, who's up next? I've got various things open, so
you have Mr. Ellerton.
Okay, thank you, Mr. Ellerton.
Good morning, sir. Morning, Commissioner. Have you got my evidence in front of you?
Yes, we've just had it provided this morning, so again I'll just find it and open it up.
Yep.
Can I ask you, Mr. Ellerton, it sort of finishes the copy we've been given finishes very abruptly at paragraph 18, and I'm just wondering whether you pressed send before you'd finished, or whether you've got a subsequent version, or you've given us the earlier version.
No, I think I've kept it nice and clipped for you today.
I know, but I'm just saying paragraph 18 just ends mid-sentence and then goes nowhere.
Yeah, good point. No, I think you're right. That's okay.
Well,
maybe
you can just add in the words that complete the sentence when you come to it.
Yes. Yeah, we'll see how we go. Thank you for pointing that out. I thought even though it's short, I'll still skip through a bit of this to keep it efficient for everybody. Paragraph 2, I have a financial interest in a property at 42 Egmont Street known as Chamber House. This property has 6 tenants currently, and the property is identified as having heritage values. Paragraph 5, perhaps the last sentence, my principal changes sought relate to sections signs R5, S4 and S11. As a general comment, the signage rules are significantly more extensive than the operative district plan. The readability and accessibility for use by lay people, in my opinion, is a little bit problematic. My principal submission is as follows, and it really focuses on the sidewalls of buildings with heritage values should be able to be used for signage for tenants, third parties, and include digital advertising. Signage is recognised in the city centre design guide that the plan references throughout the sign section and elsewhere in the plan. Next page, part 3. The reason signage is so important is that it can provide useful income that allows for the ongoing maintenance of heritage buildings to be done, and it can also make the city centre zone, more interesting and add to the vibrancy generally. Potential coverage area of sidewalls of buildings should be more generous than is proposed. Having read the Section 42A report, I think it's appropriate to recognise the officer, Ali Gibson, for adopting a large number of amendments sought by different parties. With regard to my specific submission regarding the heritage building signage on sidewalls, which is very specific, there is no apparent change. It is good to see that elements of the Auckland Unitary Plan with regard to light emissions from digital signage have been incorporated into the Section 42A report and the proposed district plan. I disagree in paragraph 163 of the report that the resource consent pathway is appropriate for sidewall signage. If criteria can be derived for building facades, arguably the face of the building, the sort of pretty part of the heritage building that needs careful consideration, then the bland and typically unloved sidewalls could also receive a usable permitted standard that does not exclude heritage buildings. In the case of Egmont Street, 42 Egmont Street, a building or structure could be constructed on the adjacent car park, which we'll see in figure 1, and the sidewall could be hidden or partially obscured as of right. The oxymoron is that we cannot obscure a sidewall with any usable amount of signage, which suggests it needs protection. But on the other hand, it can be obscured in full or partially by another structure with impunity. So my main points again are regarding prohibition of signage on sidewalls of heritage buildings and digital signage. So figure 1 illustrates the sidewall of 42 Egmont Street, which is that's roughly about 200 square meters of wall there. The sidewall has 2 windows and a doorway that were installed in the 1970s. These openings were installed when the adjacent lot was demolished around that time. So that's figure 2 illustrates what it was like up until about the end of the 1970s. And figure 1 is actually as it is of today. In figure 1, you'll see in the sort of the bottom left, there's a sign there. It's a WIT advertising sign, and we talk about that soon. The proposed district plan restricts signage on that sidewall that you've seen in figure 1 to 1 square metre. The WIT sign currently is 1.9 square metres. Proposed district plan does not permit, through its rules, for tenants of the building to advertise their presence. I was advised by council that the district plan would allow me to cover 100% of the wall in art, but that art couldn't have a specific business marketing theme incorporated if you were trying to be a little bit clever with your artwork. So figure 3, so that's a 2-scale model of the building and surrounding structures, illustrates what a 12 square metre static or digital sign would look like on the existing wall. The chap in that image there in figure 3 is Thomas Bates, who was the architect of this and many other buildings in New Plymouth. So that particular graphic on the side there is about 12 square metres. In my opinion, when looking at figures 1 and 3, it is apparent that a 1 square metre sign is inappropriately small, and that the coverage of part or a bit more of the side wall would not be an appropriate thing to do. That's the rest of that sentence.
Okay, can you just read that for me again?
It's apparent that a 1 square metre sign is inappropriately small, and that the coverage of part of the side wall to a greater extent is appropriate.
All right, thanks.
That concludes my evidence, and the rest is just attached markup of the proposed rules.
Thank you, Mr. Allerton. Seeing I stole a show earlier on, perhaps Commissioner Littlejohn could start with some questions of you.
Yeah, sure. Can you take me to the take me through the markup at the end there to see where you've suggested, so I can see where you've suggested changes?
Yes, certainly. So R5, sir.
R5.
Under the permitted activity standards is part 5.
R5. Okay, so that's the red
on the street
there.
facing facade only, excluding side walls. Yeah.
Okay. So that would have the consequential effect of not applying any standard to signs on sidewalls. Is that right? Is that the intention?
It is, yeah. Until we get to S4 and S11, sir, yeah.
Yeah. Take me there. Have you made any other changes there?
No.
Per tenant.
S4. It's one of the issues that has arisen is the way I read the plan is it doesn't assume, but it's written as though there's one building, one tenant.
Yeah.
And so what you
Yeah,
find is with a building like this, there's 6 tenants, and you'll hear from Mr. Igdale soon next about multi-tenancies in multiple buildings. So so it's really at the moment certainly for sidewalls, we couldn't put up 6 1 meter squared signs for 6 tenants so they could tag themselves as being in that building. So it gets a bit not congested, but just gets busy with trying to let everybody indicate where they work and perhaps the services they offer and so forth.
I think the answer is you could do it, but you just need a resource consent to do it. So you'd have to go to council and say, here's this building, here's the signage proposition we want to put up, and they could then control things like the size, the shape, the color of the signage, so that they were trying to make it as consistent as possible. I guess, and this is the really interesting thing with signage, and you make the quite opposite comment that they are very, very complicated rules. I mean, I don't think there are many chapters in district plans that are as complicated as signage chapters, and it's because you're trying to regulate content for effective resource management reasons, which is bound to be confusing and complex, I have to say.
And it's very and being a very subjective subject.
Oh, absolutely.
Unlike something as precise as noise.
Yeah.
But the other thing is, I suppose when I first looked at the rules and I saw 9 pages, I thought, if this is the answer, what was the question? And obviously there were some problems with the rules in the operative district plan, or the way that they were implemented by people, and fundamentally there was big problems in the residential area with whole fences getting plastered with signs, and nobody wants to see that, and it was shabby and didn't do anyone any favors really. So I understand why that needs to get tightened up, but I think certainly in business zones and city centre zones, we do want this vibrancy and this ability for people to say where they are, for us to go and find these different services if we need to. Sure, it needs some control, but I think maybe the answer is just a little bit more than was needed.
Well, I think traditionally a lot of councils have seen the subjective debate around content as something they don't want to put onto the resource management stage, and have regulated using the bylaws, because then it's the first chance that, well, the one and only chance that anyone's really got to contribute to that process is through the bylaw setting process. And then once it's in place, it's there is no notification needed. You can get a dispensation under the bylaw, but it's just you and the council. You're not worrying about whether your neighbour likes the colour that you're going to put on your sign and that sort of stuff. And it's some councils have gone down that route, and others have now put it firmly into the resource management space. I mean, and your point around content is really, it's emphasised by the fact that if you look at your figure 1, if you were to propose some sort of eclectic modern art rendition to that sidewall, everyone would say, well, hey, what a great contribution, what a great mural for the public space. And then people would probably get upset when the neighbour went ahead and put a building in front of it when they redevelop on the block.
Yeah, and your point with the mural is, within somebody doing something, there's not lovers and haters, but some people will be ambivalent. Some will love it, some will hate it. You're never going to make everybody happy, I guess. And you're right, you might only half obscure it with a building that's permitted and legitimate. And that's not a worse outcome, but less than ideal outcome.
Yeah. Yeah.
And I think S11, sign S11 is the where we circle back to having controls in terms of signage size.
Oh, okay. Yeah, in your version, your S11, is the red underscoring?
That's mine, sir. Yes.
Okay. Okay. So what you've endeavoured to do there is, by virtue of changing rule R5, so on a scheduled heritage building, it's permitted where on the street facing facade, the sign is not for the purposes of third party advertising, but essentially it is keeping the door open for a sidewall signage on a heritage building, but then standard S11 would kick in and it would make provision for 50% or 50 square meters, provided the signs are attached to their full width and length of the facade of the building or painted directly onto the building. And by removing the excluding scheduled heritage buildings, you've effectively included them within that standard.
That's the intent, yeah. And the maximum signage area, I think, was cribbed from the unitary plan, Auckland unitary plan.
So just to clarify then, are you in S11, you are suggesting that the underlined red section would replace the one above?
No, it was, yes, sorry. Yeah, so that should have been struck out. Sorry, yeah, because it went from
that's a replacement.
Yeah.
So the intent is for S11 to control size of signs on sidewalls of scheduled heritage buildings. Okay, all right. No, that makes sense. Okay.
Or any building, in fact, yeah.
Yes, yeah.
So
of course.
rather than excluding heritage buildings, just I'm not saying don't refer to them, but don't exclude them from.
So if the owner of 42 Egmont Street was to go out there and paint a mural on there, would they require a resource consent as it currently stands?
I don't think so, no, sir.
And do you think they would require one under the proposed district plan rules? Technically, it's not signage, is it?
Well, that's the thing. We did have obviously an informal discussion with a council officer, and you can paint whatever you want on there. If it happened to incorporate, you know, something to do with the business or an 0800 number or something that obviously connected the imagery to a business, then obviously that would fall foul of the signage. Then not be signage, whether it's third party or somebody inside.
I'm just looking at the definition, and it would, if it was just art and didn't have any purpose other than for the enjoyment of the passerby, whatever that might be, then it wouldn't be a sign, so it wouldn't be captured. Yeah, okay.
Yeah, I think there was some wording around urban art, I think was something. Yeah, so if it was, lots of, I don't know, it's difficult because if it was lots of musical notes and something attractive like that, but then had 0800, let's say Marshall Day acoustics, then,
or the tenant was a musical shop. you know, that,
Yep,
that
'cause
sort of thing.
But then it's still too big, you see. It's more than 1 square metre.
All right.
Hmm.
No, it's an interesting issue. First time I've actually had to get into it in the context of a district plan review, because you're very much regulating the commercial opportunities for building owners, aren't you? By being able to add value to their tenancies,
yes,
or by advertising, but also when you get into third-party signage.
They're both saws, darling. They do different things.
Mute, please.
Sean.
Oh shit.
Oh,
Not helping.
Well said.
All right.
Yeah.
So, and when you get into third-party signage, and I mean, look, I had one of my some of my first jobs as a barrister were to go in front of the Signs Bylaw Committee at Auckland Council for OG and various other billboard companies, and try and get billboards, you know, massive ones on motorways approved, and to be told to politely go home by Juliet Yates, who was the chair of the Sign Bylaw Committee. And you know, they were so hotly contested, because it was seen as using the field of view of the average passerby for commercial gain.
Wow.
And we didn't want a city that, you know, allowed public spaces and public vistas to be cluttered by people making a coin off it.
No.
And I mean, we've sort of grown up a little bit around that over the years, but you can see why third-party signage is so hotly regulated, because it's a direct opportunity to use the public field of view for private commercial gain.
Yeah, the third-party thing, perhaps if I can just add, always sounds like you're going to make $1 off it, but it could actually be could actually just be a public notice. It could be could be a government, well, it might be a government one about COVID, or a council one about the upcoming plan review. So there is obviously a commercial side to these things, but there is also the opportunity to weave into that an element of public good.
Well, even some of the old criteria for bylaws exemptions for sign would go to that level of evaluation, whether the content was for public good purposes, for example, or was providing traffic safety messages, for example, and then the bylaw exemption would be conditioned such that the billboard could only be used for the following third-party displays, and they excluded, you know, advertising for goods and services from, you know, private businesses, but you could do other stuff. So you know, again, it's a really interesting.
And with the advent of digital signage, which you may hear about more of or not, you know, they're becoming more and more accepted, and the technology is a lot better about that. But just as you said, the road safety thing, I thought it'd be quite ironic if you were busy looking at a billboard about road safety and then had an accident.
And had a crash. Yeah. Yeah.
Not
Okay.
sure that
All right.
well, didn't help my argument.
No. Look, I mean, I understand the position, and the 42A report is, you know, I mean, with respect, done a good job at trying to grapple with these issues, but it is all about regulating those rights in a way that doesn't end up letting these very public spaces become very cluttered, confusing, and discordant with lots of different visual noise in a way. That's the whole objective, I think.
I think
and I don't think.
Sorry, I think you'll hear from Mr. Ekdale next about one of the topics you touched on with regard to the cost. What's the cost implication? And I'll let him talk about that a bit more. But
all right. Okay, Mr. Allerton, apart from acknowledging the interesting irony that when we were at school together many years ago, I never expected you would ever one day call me sir. So I very much respect the fact that you're complying with that convention, but you don't have to.
Yeah, we'll just keep it to this forum though. Thanks.
All right. Thank you, sir.
Yeah, thank you, Mr. Allerton. I've got a few questions about your figures 1, 2, and 3.
Yes, sir.
Just to get some orientation. Let's start with your figure 1.
Yes, sir.
So that's King Street we can see on the signpost?
It is, yes, running across the page.
And the sign and the street going up the page is
Egmont Street, sir.
Okay. And there is a mural next to you, isn't there?
There is.
On that photo.
Yes.
What is that supposed to be?
It's by a local artist called Malaki, sir.
Yes.
And he's known for certain, I guess, characters or imagery that he uses. So I should have taken a better photo so you could have seen it, but there's the one just that you're just missing on the right there is he's got an astronaut character that spends a bit of time floating around in space, and then the D-side dog is another one of his often done characters, if I can call them that. Yeah. So it's
yeah. So that's the sort of art that could go in your building.
Yeah, potentially. Yeah. We have had some art on the building before. There was a local artist called Lisa Robbins. She's no longer in New Plymouth, but we let her have some, a couple of different spaces on the wall there to put her things up, to either promote herself or just to first sort of foray into these sort of things. So it's like, yeah, put something up, sort of give it a crack. Yeah.
And is the Malaki art well loved around by everyone? Is that or does it divide people?
No, I think I haven't heard a negative thing about it, and a lot of people will stop and get run over in the road taking photos of the wall. But yeah, no, it is a good thing, and there's quite a lot of that sort of urban or street art around New Plymouth and many town centres dotted around here.
Yeah. And so this is just again to get my context. The figure 2 is same site but slightly different location.
Different angle, yes, sorry. Yeah, slightly different angle. So you can see the front of 42 Egmont Street there with the big columns, and then where the car park is an old, I think they were lawyers or accounting firm, and that building was derelict and torn down, I believe, in the late 70s. Yeah.
Okay. Are those other buildings in that site still there in that figure 2?
Yes, they all are. Yes. So the one that says Armstrong and Springhall is the Egmont Business Centre and Fredericks Bar, and that's still the same. Obviously, different paint job. And then the background is I still call it the Opera House. TSB Showplace that's the fly tower for the Opera House, and all the other buildings on Egmont Street are still there. Yeah.
So in figure 1, has the Opera House got something added to it over figure 2 or look at things, some new structure?
Yeah. Yes, it looks like they've done a bit of an extension there.
Okay. So I'm just trying to look at the streetscape and talk to you about why signs are sort of controlled in these heritage areas. The 2 buildings at the end of Egmont Street, they look like they might be gone now. Is that right? Between figure 1 and 2?
At the far end of figure 2?
Far end, yes.
No, they're still there. There's the original TSB Bank is one of those. And no, those buildings are all still very much there, sir.
Okay, because I'm seeing some trees in figure 1 at the end of the street, not buildings. So maybe I'm just
planted on the pavement, sir. Yeah.
Oh, so they've come up on the pavement.
Yes.
All right. Sorry. Yeah, and with your changes to S11, you're suggesting that either 50 square meters or half the building.
Yes, sir.
The side wall. So
sidewall, sir. Yes.
Looking at figure 1, that could pretty much be right up to where so that whole corner of your site, right up to where the blue starts, where the windows are. Would that be about 50%?
Yes, sir. So obviously the blue is the old light well.
Yes.
Yeah, and then for argument's sake, that first part would.
And so your changes could see any sort of sign go on that half the building?
Yes, subject. Yep.
Subject to anything?
I'd have to check the rules again, but there's still, I think, rules around. Obviously, you can't have it extending above parapets or outside edges, and that makes sense. Yeah, up to 50% or 50 square meters.
Okay.
It was larger, yeah.
And was your intention with figure 3, which is your rendering off the area, that what you got there might be appropriate with some recognition of a local architect and then some other signage? Or was that what were you trying to display there?
Well, that's just to show what 6 by 12, 6 by 2, so 12 square meters would look like in the context of that wall.
Yeah.
Just to show what a 12-meter sign might be like. So whether that was a digital sign that was 6 meters tall by 2 meters wide, or maybe that sort of dimension of building would lend itself to something more of a banner rather than, in that instance, that might be 12 square meters whereby tenants, the 6 tenants could all have their name as a bar.
Yeah.
They already do on the front door just as a strip, So the idea was just to show what 12 square meters would look like on the side of that wall.
So the 12 square meters, again, I might be missing something, but
it's just an arbitrary amount, just to say, well, this is what 12 square meters looks like.
But you haven't asked for 12 square meters, you asked for 50 square meters, or
That's
half
right.
a building.
Yep. That's right.
So is this just something that is just somewhere underneath the limit that you're seeking?
Yeah, just simply an example of what 12 square meters look like. I could mock up what 50 square meters looks like, or some other amount, but it was just tinkering around, sir.
Okay, no, that's good. And I don't think we're hearing any evidence from landscape architects or urban designers on these sign issues. Certainly they were alive and well in Christchurch when we were talking about the same issues about the relationship of signs and heritage areas. So is your building at 42 Egmont Street, that's scheduled in the plan as a heritage building?
Sir, yes.
Yeah. And the other ones along the street there are as well, do you know?
I would imagine so. There'd be a number of those, yes. Yep.
Yeah. So in the Plymouth context, you could say this was perhaps a bit of a heritage precinct where the old buildings are being protected by the district plan.
Yeah, well, certainly, I guess not quite the original, but the older part of town, if you like. And once they started using concrete, obviously the buildings could last a bit longer than the old wooden ones that they replaced. And certainly, there's in terms of the heritage values, I'm fully supportive of protecting the pretty face and the facades and those parts of the buildings and architectural features. Just in this particular case happens to be a rather bland and sad side wall that could be utilised to generate some income in order for the ongoing protection of the building. But also, there is that ability, if you had 50 square meters, to have a bit of community art as well. You can have both, in my opinion.
But your changes you're seeking could let you put anything on there in terms of advertising, community art, advertising tenants,
Sure, yep.
Okay. And I don't think as you're not a specialist in this area, I can't really ask you any expert questions, but I will ask you a question about just as a layperson in this area, do you see any issues as a resident, say looking at figure 2, if you're walking along the other side of the street and you saw a sign that was very dominant advertising over half the sidewall on 42, whether that would, I suppose this comes to the subjective matter. Sounds like
very subjective, sir, and to be honest, I've got a vested interest, so my answer is almost certainly going to be no. I don't think it'd be a problem, but
that's fair.
You'd expect that. So.
Yeah. Okay. All right. Well, that's good. I think we understand your your submission. So thank you very much for
Thank you for your time.
presenting it. Thank you.
Thank you.
We are now moving to Mr. Ekdal. We've normally taken a break about this time just for just a quick comfort stop, which I think we'll do again. So it's 10:40. If we could just come back at 10 to 11, so that gives us 10:50, 10 minutes, just to have a quick break, and we'll talk to you then, Mr. Ekdal. Thank you very much.
Okay, thanks for that.
Thank you very much, everyone, for joining us again. One thing I've just noted and thought about over the break, obviously with submitted evidence that isn't pre-circulated, we're just receiving statements. For example, we've had a number of statements just come in this morning we're referring to, and the rest of you won't be able to see them. But I think following on where we are looking at figures and information, we'll try and get those up on a shared screen, I think, Julie, if we're looking at visual material. I understand that the council's 42A officers would have also received the statements from the parties, is that right, that have come in just recently?
In some instances, it just depends when they've come through as to whether
Okay.
I've had a chance to flick them off.
Okay, so yeah, just so obviously there's these statements will go on the website after today's hearings, but because they've just come in, we're just dealing with them as we see them. So we'll try and bring up on the shared screen anything that's visual that we perhaps can talk to. So thank you very much. Mr. Ekdal, it's over to you.
Morena, everyone.
Morning,
Thanks
Morena.
thanks for having this happen today. Look, I'm just doing a statement on behalf of Ekdal Property Management, and this is the first time I've been involved in a plan review process. So I'm going to work my way through it and hopefully don't muck it up too much. But essentially, I'm just been working my way through the district plan rules, or the new rules to be implemented, and I'm thinking I've got to understand these, and then my current tenants, or our current tenants, or soon to be tenants, have to understand them as well, which got me a little bit interested when I started to navigate through it. Our company manages approximately 65 or buildings with approximately 65 tenants in the CBD, where these sign rules are going to become implemented, but also approximately another 20 tenants in the local centre zones. And they all range from the local barber shop through to government agency type tenants. As you'd expect, these tenants, depending on what they do, they all have quite a different wide range of the type of advertising they might need to do, or even if they don't, or even if they need advertising. For example, government tenants don't actually require to do anything like that. And some of the buildings do have heritage values, as Damien mentioned earlier. I sort of feel the rules are quite difficult to read and actually put into practice, really, for a non-resource consent trained person. And I think signage is a really critical piece of a smaller business operation to get their message out to the public. It says what they do, what they've got for sale, what they've got on offer. And given the fact that small business in the New Plymouth CBD and local centre zones make up the lion's share of what's on offer, and they generally operate on minimal cash reserves, as we've learned in more detail with this recent COVID outbreak, having a limit on their signage really does put another financial strain on this hard-working group of businesses. That's why I think it's important. I sort of think it's important that the council are more lenient with the rules proposed, and maybe a more sensible approach, given the fact that they're undertaking a review of the CBD and implementing a CBD strategy. They've been working on it a couple of years now. That these rules maybe are part of the overall CBD strategy, that they aren't treated in isolation when they're trying to keep our CBD alive and active and that sort of thing. I sort of think it should be all linked together. And based on the research I've done, and I've got some photos attached in Appendix B, I think some of the proposed rules in the proposed district plan are just not practical. And I can't see that our signage at the moment in the community is really a problem. I was aware of the council having an issue with some residential properties that were taking advantage of their location on corners and plastering their fences with signs, and that's, I understood that to be a bit of an issue, but I've seen nowhere where commercial signage in New Plymouth CBD or local centre zones is an issue. There's been a lot of talk about third-party signage in Damien's earlier submission, but really third-party signage, apart from a couple of key locations in New Plymouth, really doesn't have a big presence. It's our typical areas for that third-party signage tend to be on really busy intersections. I've got an example of some third-party signage where neighbours of adjoining properties share fences or share a sign, even though the sign might be on one property, they're sharing the signage space to market the other property adjacent next door. And by definition of this new rule, that would be deemed third-party signage. Recently, we looked at what it would cost to get a resource consent for just a general sign. And I received a quote for $5,000. It's quite cost prohibitive to spend that sort of money on going through a resource consent process when you may be only a business paying $15,000 to $20,000 a year in rent. It's sort of out of context with what a lot of these people can afford to pay. There are a lot of vacant buildings in the CBD at present, and the New Plymouth Council is in the process of a CBD strategy. And I believe, as said earlier, that this should be part of that strategy and not in isolation. I've also got images of 20 vacant buildings in our CBD at the moment, from Gover Street to Rove Street. Some of these have been vacant for more than 12 months with no interest from prospective tenants. And as a result, they lose their existing rights of signage after the 12-month period. So the new rules would need to apply. And I think it becomes very difficult for people to consider if they're going to commit to a lease and they're thinking, well, I want to commit to the lease, but the reality is I don't know what I'm going to be allowed to do with signage. Therefore, they go and employ a consultant, and all of a sudden the property doesn't get leased out. And it just amplifies the problems in the CBD. Attached is Appendix A, which you'll have in front of you, which I've made some comments on, and that links with the photos further down. I hope this helps for the information I put in front of you.
It certainly does, Mr. Echtel. I know these hearings can be a bit daunting, but you've certainly taken the time to think about things for both your own business and the city as a whole. And your statement has been very clearly written, and I certainly appreciate the table in Appendix A where you've gone through in quite a bit of detail looking at each of the specific areas and with your comments about those relating to the proposed rule and the existing rule. So I'm sure that will be of assistance to the 42A officers too when they come back to us with their right of reply, because it's an interactive process, as I think you appreciate. The plan's notified, submissions come in, the officers have a think about those submissions, and then we hear from submitters, and then there's a right of reply, and we have to make the final decision. So yes, just really appreciate your involvement. Look, I would like to just get you to explain some of your images in Appendix B.
Certainly.
I'm wondering, Julie, could we share that on the screen? It's in from page 8 onwards. So these are some examples. Can you just talk us, I don't know how many you've got, but just talk me through what you're focusing on here with the first one?
Yeah, certainly. That's a heritage building we manage. It's called the Colliers Building. It's recently undergone a repaint. And and it's been waterproof and so forth. And that elephant was painted on the back of the building maybe 10 years ago. Unfortunately, it had to be painted over to waterproof the building because the paint, it's a concrete building, and the paint was needing to be replaced or repainted, and unfortunately lost the elephant. So that's an example of a heritage building. It's actually got 4 facades because it's standing alone by itself, and it's had graffiti or mural or whatever you might want to call it put on the back wall, which we're hoping to actually put something else back there in the future, just consulting with the council on that. But yeah, that's an example of what a mural can look like on the back of a building, but also leaves the east and west walls with no signage abilities under the new plan. And that building does have a tenant in there. That's example of that one. Yeah.
So could I just ask you about the other walls? So has this building sort of been left isolated where other buildings have been knocked down around it? Just the context?
Yes, it is. Yeah, so that's why part of the reason we had to waterproof it, because the buildings around it had been knocked down and created the Hirataki Plaza. And as a result of that being knocked down, there was exposed concrete there, and that was allowing water into the building. And given that it was a heritage building, we had to replaster the building where the old buildings had been knocked away, and then put paint over it to seal it up to stop the water getting in and rusting the reinforcing within the building.
So this is the Hirataki Plaza with the Hirataki River coming through?
Yep, that's right. Yep.
Yes.
So that's an example of it. It's cost quite a sum of money to do that, but it'd be quite nice to be able to have some sign. Like, we're quite keen to give back to the community in terms of having murals on the building, but we also need to gather some revenue to keep the maintenance on the building also. So it's and that's what Damien was referring to earlier.
Sure. But would you agree that if Damien's suggestion that you could cover each of those 3 walls, I suppose, is with 50% signage as opposed to murals, that could be covered by advertising potentially under that provision rather than just murals?
Yeah, potentially. You're right. Yeah, you're absolutely right. But I don't think it's an area where there's a lot of people be interested in doing third-party advertising on the building, because it's not a high traffic flow area.
Okay, but I suppose it's just
those sort of
guard against district plans, always thinking about what may happen in the future. So particularly those permitted activity rules where you're allowed to do things without consent. Okay, we'll move on to the next one.
I've got a good example of. Carry on. Yeah. So that's another. That's the building with escape written on it. That's a heritage building. It's across the road. It's on the corner of Egmont and King also, and it's got a tui painted on the side of it. But that escape sign there, that is 1 square metre on a heritage building. That's the limit of the signage allowed on a building under the proposed plan. I've got another photo, and that's when we originally started, or that's before we started renovating the building. I've got another photo further down of after we've renovated it, and you can see more signage on the building.
Okay.
It's way down anyway, but yeah.
Yeah. So is anyone particularly that you're interested in focusing on? Because
look, if we as an example, under the new rules, that Elco canvas building, the sign's not allowed to go up above the facade. So that's not permitted under the new rules without going through a resource consent. That's the sort of examples I'm showing, and it doesn't look that bad, and I'm sort of wondering what we're trying to achieve. But it doesn't seem to be that there's any big problems in the CBD or the local centre zones.
Okay, I can see the point you're making there.
So I've got a few examples in these photos.
Yep.
This here is another example of the veranda signs that go up above the front facade. They're not permitted, and yet to me that doesn't look like a problem that needs fixing or restricting.
Okay.
These signs are all out in the local centres, or it's in the Fitzroy area called the local centre zone under the new plan. All these signs that these businesses use to promote their business activities and what they're doing are not allowed under the new district plan because they're above the veranda. You're not allowed signs above the veranda.
Okay. So they were approved, they were allowed under the previous plan, is that what you're telling us?
Yep, there's no rule disallowing them, so they, yeah. But they're not allowed at all under the new plan.
Okay.
These ones here, that's the picture of that commercial building that we looked at with the tui on it. So we've since repainted that. And so once that building's now got, as a result of renovating it, we've now got 15 tenants in that building. It's quite familiar to most people in New Plymouth. It's got the Fredericks Bar on the corner and Jet Charm. But also, like you have 15 tenants and you've got the limit of 1 square metre of signage per road frontage. It's just not a practical solution to ensuring that the building survives into the future, because you won't have tenants if they can't tell people they're there.
Okay, yep, thank you.
And just, it doesn't, there's another, that's another heritage building there. That's called the King's Building. I just took a picture of a corner of it, really. But that Lotto sign along there alone, that's 1 square metre. That's what's allowed for that entire building.
So this is the point about tenants as opposed to buildings that Damien Ellerton was saying. Yes. All right, understand that. Thank you.
Yep. That's an example under the new rules. So that's a building we manage for the IRD. Under the new rules, I think it's you're allowed up to 15% wall coverage. Well, that sign's 10%. So that's going to give you an idea of the size of the sign you're allowed under the new rules. If that was going to be a retail shop or something like that, without going through a resource consent, that's the limit of their signage.
Okay.
Here's a good example of, this is a brewery on the main street of town. He has got, well, as you can see, the whole front wall is advertising his bistro, or the facade. He's covering about 80% of his front wall and facade. And it just doesn't look like it needs to be restricted. Example of Spark.
Yep.
That's that one's 60% site coverage. Is this, wherever you look, it's this sort of yeah.
Yes.
That's
okay.
90%. Yeah.
Yep.
This is an interesting example. This is Dulux, and they've gone, the building on the left where they've got the dog sitting, that's actually a neighbour's property. And that's an example of where Dulux have painted onto the neighbouring property. So essentially, that is third-party signage and exceeding the 15% rule. But that would normally have to go through a resource consent and as third-party signage on the property next door.
Okay, thank you.
Federal Store, another well-known, that's at least 50% site coverage. Fitzroy Automotive, 50%. It's just the percentage seems very restrictive. That's an art gallery in New Plymouth, and this is where it gets a little bit confusing. What's the size of their sign there?
Yeah, interesting. Yep.
Yeah. Mad Mex that you're talking about earlier. This is Mad Mex. They've got 100% coverage of that wall. You can see Mount Egmont or Mount Taranaki on the left. Mad Mex, but it's got the Mexican theme. That's 100% site coverage. Advertising their business. Property brokers, same thing. Under the new rules, TSB showplace, you're not allowed signs above the veranda. It's a heritage building. Under the new rules, you're not allowed that above the veranda. 1 square metre of signage. Oh, it's another photo of that one previously. I must have doubled up. So this is an example of 2 tenants side by side sharing third-party signage. So the new rules state that you can't start the sign until you're 2.5 metres above the footpath. So you can see the arrow on the left-hand side. That's where you have to start your new sign from. And then you're allowed a maximum of 5 square metres. And there's the one on the right-hand side of Carter's tyres, you know, like you'd have to start that 2.5 metres up. That's an 18 square metre sign. And here's other examples of signs all through town that break the rules. This is, once again, a group of signs under veranda signs, but I'm a bit confused on this one because under S9, it says the separation distance between signs has to be 50 metres. But yeah, I might be reading that wrong.
All right, well, thank you very much for taking us through those, Mr. Ekdal. Certainly the examples are very useful. I think your evidence and statement is very clear to me, so I don't have any further questions. We've talked your way through those aspects. Commissioner Littlejohn?
Yeah, I'm off mute, aren't I? Yep. Yeah, just a couple of things, Mr. Ekdal. It's quite helpful to have someone who actually owns and operates buildings in the CBD giving us evidence. And some of the questions I'm going to ask you have probably got nothing to do with your evidence, but I'm going to take advantage of the fact that you're here. Because our last hearing topic, we had a lot of evidence about the ailments afflicting the CBD and vacancies and all of those sorts of things. So there's a couple of things I wanted to get from your perspective as a person who's got their sort of hands amongst all of it. And I guess that's where my first question is. In your paragraph 17, you talk about there being 20 vacant buildings in the CBD, Devon Street only from Gover to Robe, and some have been vacant for more than 12 months. If you know, what do you say is the reason for these lengths of vacancies? Is this extraordinary, or over your long history of managing buildings in the CBD, have buildings sort of sat vacant for a reasonable period of time before getting re-tenanted? Is there something happening now that's different to what's happening in the past, or is this just fairly common for the New Plymouth CBD?
I think it has fluctuated over the years, but what I've noticed in the last 4 or 5 years with the advent of online shopping and online shopping, I guess, was probably the beginning of the demise of the retail. Or no, and then you've got the Valley Centre, which opened up to big box retail. All of those things probably contributed to being tougher to survive financially as a retailer in the CBD. And then what's happened in more recent times is COVID struck. Everyone's become a lot more confident with buying online. More people understand how to use the internet and the computer. Freight companies have improved their service. You can order something, like I ordered something from Repco a couple of weeks ago in the morning. It arrived in New Plymouth from Wanganui at 3 o'clock that afternoon. So everything's just, the stars have aligned for online retail as a result of COVID, I believe, because everyone's just got more used to it. Then also what's happened recently is a car park building that's owned by the council has recently been found to be earthquake prone. That had approximately 250 car parks. I'm not sure exactly the number, but approximately 250. That building's now been shut down. So there's a big shortage of car parking in the CBD for businesses that want to maybe rent space and have a permanent car park for their staff or themselves. And then also there's been a lot of discussion about the cost of car parking in the CBD if you want to whip into town and run in and get a key card or buy a pie at the bakery or whatever the case might be. So all of those things have been up for discussion quite a bit, and it's interesting that no decisions have been made on car parking or the strengthening of the earthquake-prone building until the wider CBD strategy is known, and yet they're reviewing the signage rules, which I sort of feel that it should be all done as one.
Okay. No,
the 20 vacant buildings is also a few months ago, the council announced that we had to have some rates increases, which we all accept. But the current CBD rates per $1,000 worth of land value is currently 4 times that of residential rates. So what I mean by that, if you have a $500,000 section in your Plymouth residential area, your rates would be approximately $4,000 per annum. If you have a $500,000 section in the CBD with a retail shop on it, your rates are approximately $16,000 per annum. Now, those rates are about to double over the next 10 years. And so you've just got all of these things happening in the CBD in the last few months that are making people very, very reluctant to commit to taking on a lease and making ends meet.
Yeah, that observation around the rating is really quite interesting in a way, because I think historically, when business areas are well used and fully tenanted and viable, they are seen as attracting much greater value per square metre, and therefore historically have always commanded a greater rates proportion. And of course, what you're seeing here is actually the more valuable land, because it's got the greatest demand on it, is potentially residential, because of the growth rates coming into New Plymouth and how valuable it is. And so maybe, and this is really me just thinking out loud, we've got no control over council's rating policy. Maybe there needs to be a rethink about the historic proportion of rates carried by commercial land versus residential land, given the way in which the commercial rates per square metre are potentially dropping significantly on what they were historically because of all of these other macro factors that are impacting. So anyway, that's again nothing we can influence with the plan. But
you're exactly right. The retail sector, when I was a child, you could only go and buy your shoes at Hannah's, and that was it. So if you had a retail shop in the CBD 40 years ago, you're probably making quite good coin. But there's a lot of other factors that have come into it now that don't really allow that to happen, and it's quite tough work for them. And then you throw this additional factor in there of the signage complications, potentially, or restrictions, whichever way you want to look at it, and it's just another negative aspect of considering leasing a commercial premises in
another barrier to entry for a sort of a startup tenant in a way coming into the CBD, isn't it? Yeah.
And that's yeah, sorry.
The all of the buildings in your Appendix B are vacant, did you say?
Yeah, they're not all our buildings. I just went down Devon Street. No, not ours. To be fair, that was just photos of buildings I took off Devon Street.
Yeah. The one you had a couple of pictures there, brings back quite long memories for me. The Egmont Leather and Canvas building, that was where my father established the Egmont Leather and Canvas. He was a canvas maker. He did his trade, and I remember as a boy up in the top there, they used to make all the awnings and stuff with the big industrial sewing machines, and I remember having to go in there in the weekends when I was a bad boy at home and just have to follow Dad around with the sewing machines and everything. So it's a real a bit of nostalgia on that page.
Well, it's lasted the test of time, hasn't it?
Yeah, well, it's still the business brand is still there, and I must say, Dad has still got the original sewing machines from up there, back at his house, and he still repairs awnings with them. They're very hard to find. Yeah. Anyway, back on topic. Sorry for that segue. a little bit of nostalgia. Hey, now I just wanted to question your paragraph 14. This quotation to get a resource consent, was that just a consultant telling you that's how much they'd charge you for the job, or did that include all of the council processing costs as well?
No, that's it was made up of 3 parts. Yeah, there's 3 parts to it. But yeah, I just got a quote from a local engineering company in New Plymouth that does resource consents, and that's what it amounts up to go through to go get a resource consent for a sign to go on a commercial building in the local centre zone.
Yeah,
and that's under the existing rules, because we're going to. So I imagine. Yeah, so that was a sign that we're going to have to get a resource consent for under the existing rules. So I imagine the cost of doing a sign, whether it's existing rules or new rules, be pretty much the same.
When and this sort of flows on from that, when you get up to your paragraph 12 there, in your experience, or is it the case that different buildings have different opportunities? So do you tell your tenants that if they want signage, they've got to sort it themselves, or do you generally lease a building with signage space attached to the tenancy, much like you would a car park? I mean, or is it a mixture based on the building?
Normally, the building that they rent has the signage allocated to the area in front of their front shop area, I guess. So if they're a line of 3 shops, and the shop's 50 metres long and they've got 15 metres of the shop front, normally they'll take the 15 metres directly up above their area they occupy, just by given right, really. Don't normally get into the detail of it in the lease. Yeah.
So if a building...
But under the existing rules, you're allowed 40% site coverage, you see, of the front.
Facade coverage,
yeah.
Isn't it? Yeah.
Yeah, it's quite straightforward.
If a building owner had, I mean, if let's say they internally subdivided their premises and doubled the number of tenancies, made them smaller, but had the same footprint, there's nothing stopping the building owner from seeking a resource consent to make provision for sufficient signage for each of those tenancies. So to make the tenancy spaces more attractive for a new tenant coming in, not having to solve their own signage, a building owner could do that, couldn't they?
Absolutely. Yeah. Yep. You could do that.
From your experience, is that what building owners do, or do they just leave the tenant to solve this?
No, not really. It's never really come up before. And as I said, the lay of the land is there's so many vacant buildings out there, you can't just expect to go into a building and if it had a big sign across the front facade that you can repaint it with your own logo in the future under these new rules, because it may have been vacant for more than 12 months.
That's a really interesting one about your existing use rights, because I guess there are 2 ways of looking at it. If the facade itself, I guess that's a question I'm going to have to contemplate. Does the vacancy mean that the right for signage expires, or does the fact that there is a physical space on the building that's got signage on it, and the moment it's there and it's not taken away, does that create the existing use right? I.e., do you have to have a tenant involved to be able to maintain the existing use right? I'm not asking you. It's something I'm sort of contemplating, because it is an interesting one about when you change the rules in a district plan to potentially make them more restrictive on things. The existing use rights do then become a hotly contested issue for people, because they will want to seek to rely on the entitlement they got under a prior regime. So that's something that I'm probably going to contemplate.
Yep.
Okay. I think that was it. And thank you for your comments on each of the rules. I haven't had a chance to go through them, but I'll do so once we get a breather.
Great.
That's great. Thank you, Mr. Echo.
Thank you,
Thank you
Mr.
very much for
Echo.
your time. Okay.
Just one question from me.
Sorry.
Are you involved with the council on their CBD strategy?
No, not really. I've been to a couple of public meetings, but not involved in it. No.
Yeah. Yeah. Like I think your input's been pretty helpful to us. So, and good things do happen when you get in a room and talk to people, is my experience. But yeah, encourage you to keep your interest in the planning area. It's pretty important for you.
I rest assured I do knock at their door a bit about it.
Yeah, okay. They're probably you might be one of the known people. So yeah.
Oh
so,
yeah, that's probably why I'm not on the committee.
Thanks very much. Appreciate the time.
See ya.
All right, thank you very much. Mr. Wood, I think, from First Gas. Zane, how are you?
I'm very good, thank you, Commissioner. Very good. So I messaged Julie last week saying that I was not producing any evidence at this point, and I was in support of the 42A report recommendations in relation to my submission. So I spoke to Julie and just gauged what I needed to do from this point on, and her recommendation was to be available for any questions you might have regarding that.
Yes, we've certainly looked at the First Gas submission, and you had some submissions about earthworks definitions, for example. So you're comfortable with where the council planners have got to with addressing your submission?
Yeah, I am. I've tried to keep a lens on that and be objective to the comments made in that 42A. It's a relatively new space for First Gas, so it's something that we're working through, I guess, throughout the whole of the North Island. You know, comments in relation to the national planning standards were, I thought, quite relevant as far as attempting to hand of God, you know, to change things that are trying to standardise across the North Island or across the planning framework. That makes sense. So I understood that.
Yes.
And I acknowledge that there was some support of what we're trying to achieve with our submission, but noting that it's, you know, possibly in this case better dealt with under network utilities.
Okay.
To get a sort of cohesive suite, I guess, as opposed to having provisions in different areas achieving similar things, I guess, was the understanding I took from it.
Yeah, that's good. I think I've seen quite a lot of interaction between the reporting officers and the submissions, and then you'll see in the right of reply that comes through, if you follow that, there's even further sort of addressing of matters that are given to us, not in submissions, but in evidence that the 42A, of what we call the 42A officers. So these are the reporting officers of council, sort of listen and make some other suggestions. So it is a good process. Could I just ask you two questions? The first is about your network, Zane. You've got a plan attached to your submission, figure 1.1, regarding your pipelines, but can you just give us just a brief potted summary about the First Gas business?
Yeah, sure. So there's different folds to First Gas Group as a business. We manage the high transmission pipelines throughout the North Island, which is a network as per that plan, from Whangarei to Wellington and across the North Island as well. That's your high pressure transmission line. So that's the feeds that are supplying gas to the different uses, both commercial and residential. Now that network comes with underground pipelines, and it comes with above ground assets to enable that pipeline to work effectively, with compressor stations, etc., just to keep the gas flowing, so to speak. As well as that, in some areas of the North Island, we have distribution, which is your lower pressure gas to residential, for example, as well. We also own a gas storage facility in the Stratford district, so out of New Plymouth, noted, but which is where a lot of storage of gas occurs in the natural reservoirs. Yeah, so we work across about 39 territorial authorities across the North Island.
Okay, so what was your predecessor called? Natural Gas Corporation, or is that something completely different?
That was TOBAC, yes, so that's correct. Natural Gas then went to Vector, and now since 2016 it's been First Gas.
Okay, And is that big storage facility, is it called Aurora or something?
Aharoa?
Aharoa, okay. That's in the Stratford district.
Yes.
Yes. So you have pipelines, you have pressure stations to boost pressure. You have your storage facility. Yeah.
Yes.
And are your customers the, if I'm in Hawke's Bay, so is it, who would you be your customer over here in terms of the system? Do you know?
When you say our customer.
So do you sell to local network utility companies, or?
We do, in honesty, I don't deal with that myself, so I don't have a good knowledge of it. I know the 700 line, the main transmission line running through there, and then down to what you'd call a distribution point.
Yes.
And from there, we either manage the distribution through to the customer, or we don't. Effectively, we operate as a supply logistics company.
Okay.
So my role within the organisation is quite varied. A large part of it is just the safety, promoting the safety of our network. So a component of that, a relatively small component to be fair, as far as my overall day-to-day, is assisting in district plan reviews to try and get us understood within districts, and to get some provisions in there to ensure that the network remains safe whilst enabling development.
Okay. So what they call the Maui pipeline, that's under your network?
Yep, so that's the 400 line, as we call it. Yep, the Maui pipeline, which is running up through New Plymouth.
Yes. Okay. No, that's really good. And you have some submissions on various other parts of the plan. Network utilities, you have submissions in that part of the plan?
Yep.
So you'll be keeping in touch with us as we go through those. So we'll perhaps see you again.
That's what, yeah, yes.
Yeah. And certainly if there's if you need to talk to us again with if there's any particular issues that you see the planners aren't aligned with where you're heading, certainly give us a statement and we'll talk to you again on those further matters.
Awesome.
So,
thank you, sir.
Thank you very much. Commissioner Littlejohn.
Nothing further. Thank you, Mr. Wood. That's helpful.
Thank you both.
Thank you very much. Right, I've lost my schedule. I just closed everything down, unfortunately, but
you have Federated Farmers next up.
Okay. Ms. Walker, how are you?
Yeah, no, I'm good, thank you. Good morning.
Yep.
We'll just wait for Mark is online, so we'll just wait for him to come up if it's okay. Are you there, Mark?
Yep, no, it's good. Yeah, kia ora. Thanks for this opportunity. My name Mark Hooper. I'm the president of Taranaki Federated Farmers. I'm also a dairy farmer at Lepperton, so just on the road from Waitara to Inglewood, not far out of New Plymouth. My excuse me, my grandmother's father purchased the first block that we're farming on in 1918, and so we have a family history on this place for quite some time. The property is known as Marae Tawa, and back in the late 1800s, due to the proximity of the Marae Tawa Pa, a town survey was done, which covers part of the farm for Marae Tawa village, but that was never built. It's slowly filling up with lifestyle blocks, and in fact we have lifestyle blocks encroaching on all sides of our property now. However, what was constructed also in the late 1800s was the British built a redoubt just across the valley from where Marae Tawa was. So that was known as the Marae Tawa Redoubt, and that overlooks the village of Lepperton currently, and there's still signs of that there. The key feature on our farm, though, is the the very large Kairoa Pa, which we have placed into a QE2 covenant. In fact, we have 4 separate QE2 covenants across the farm. And the Kairoa Pa is adjacent with Pukerangi Ora, which is up the back of Hurangi, and there's another large pa site up the back of Tikarangi. And together these three pa represented the kind of back defences of Te Ariawa. And there was a well-known track that came down between Kairoa and Pukerangiora from the south, South Taranaki to through to Waitara. So those are areas of particular interest that that we've looked at preserving and protecting on our particular property. And I give you some of this little background because these are some of the issues that we'll be touching on in our submission. So I'd hand over now to Hilary, who is our Senior Policy Advisor, and will be making our presentation. Thank you.
Thank you, Mark. Really appreciate you coming online. I know it's a busy time of year for you dairy farmers. I've got lots of old family connections in Taranaki too, so it's a busy place. So thank you very much.
Yep, at the moment.
Yep. And so we'll come back to you just
Yes.
if we've got any specific questions. Thank you. And Hilary, it's your floor.
Yeah, so thank you and good morning everyone, especially those that have just come on through the course of the morning. Sorry, I'm not going to be quite as brief and succinct as Mark, but I will, yeah, but it obviously is an important topic, so it's worth the time. So you'll probably be aware we were relatively comfortable with the notified provisions of the plan, which have been assigned to this hearing topic. Our generally supportive submission sought relatively minor amendments. And particularly with regards to Earthworks, we were predominantly focused on ensuring that a farmer wouldn't find themselves in the frustrating position of needing to get two different resource consents, one from the Regional Council and one from the District Council for the same activity. Our relief in this regard was not accepted on the basis that regional and district councils have different functions with respective rules designed to manage different effects. Now we do accept that, and we consider that our key concerns with regards to duplicated earthworks controls can be adequately addressed by the approach taken with WBR4. So given that there are no significantly different perspectives between Federated Farmers and Ms. Lawrenson's, who's the Section 42A report writer, this statement does focus on key issues which have been identified by other submitters as ongoing concerns. They are issues which we have registered opposition to via the further submission process. Specifically, we do cover policy EWP4, the accidental discovery protocols, and our frustration that increased levels of regulation are being put forward as the best and only option to address failures with the operative plan, rather than parties taking a closer and perhaps harder look at why non-regulatory methods may not have achieved desired outcomes. So firstly, turning to policy P4 and the accidental discovery protocols. We acknowledge the overlap between this hearing topic and hearing topic 14, sites of significance to Māori, is created by this EWP4. And whilst we supported that policy, a number of submitters are seeking its deletion, preferring the more targeted and responsive approach taken by the SASM P5 and Historic Heritage P6. I've included those, oh sorry, now I've just lost my, there we go. I've included those policies for easy reference, but I'm not going to talk to them in any detail. So in our view, policy EWP4 could be deleted, allowing the SASM P5 to do the heavy lifting for SASMs. There does seem to be an unnecessary and potentially confusing overlap created between the two. We also prefer the targeted and responsive planning approach adopted in the SASM chapter. The Earthworks chapter should by its nature be general and district-wide, not focusing on managing specific effects on specific values. It is worth noting that the chapter doesn't include specific policies relating to other Section 6 matters. And of interest, the Section 32 report at Section 8.2, in explaining the differences between the proposed and operative plan, states that the chapter does not relate to Section 6 matters of importance. Now, moving on to the accidental discovery protocol aspect. So we supported the inclusion of that in the proposed plan. We think it provides an important pathway to navigate what can be a stressful time for all parties involved. And for what it's worth, we don't think the term accidental discovery protocol is meant to be sinister or disrespectful in any way. It simply relates to the fact that something may be discovered or rediscovered through the course of works being undertaken for other purposes. In the context of applying to unknown sites and within the district plan context, it needs to be sufficiently general to have wide application, whilst providing some consistency and certainty. It is appreciated that it shouldn't substitute site-specific and targeted protocols, which may be required as consent conditions when appropriate. The examples provided by previous submitters made sense in the context of discrete projects with very discrete earthworks components undertaken in elevated risk areas. It is appropriate that having a kaitiaki on site in those circumstances is it is accepted that having a kaitiaki on site in those circumstances is likely to be appropriate. But it seemed to be suggested that that process should be extended to all earthworks for all activities. And we struggle to see how that approach could be applied to the rural context with regards to earthworks and cultivation that are required as a part of regular and ongoing pastoral production activities. So there are a number of submitters who are looking to increase regulatory controls for earthworks and cultivation on the basis that the operative plan has allowed for some sites of significance to Māori to be degraded and lost. Now, whilst we never condone willful and deliberate action which causes the degradation or destruction of these sites, without having a better understanding of the specifics, there are a number of reasons for this outcome. The different reasons will require different responses, from better monitoring and enforcing, to improved accuracy and extent delineation, and not least of all, to improved knowledge and understanding. We use the further submission process to register our opposition against the consenting process being put forward as the best and only solution. It continues to be our belief that win-win outcomes are best achieved when landowners are recognised and treated as part of the solution. There has been a lot of talk about partnership and early engagement over the course of the hearings to date. There is a lot of material in the various reports which outline consultation processes and how respective parties and stakeholders have been given opportunities to inform the district plan review over time. Of relevance to this hearing topic by virtue of that EWP4 are the processes that relate to both the known, so the scheduled and unscheduled sites of significance to Māori. We are seriously concerned at the lack of recognition, lack of involvement, and lack of opportunity most directly affected landowners seem to have had to date. In piecing together the consultation opportunities outlined in the SASM Section 32 report under Section 5.1 consultation, it doesn't look as though private landowners with known SASMs have been directly contacted by the council at all during the district plan review, not even by the one-dimensional over-relied on mail out. The last direct contact seems to have been through or sort of around the 2007-2008 time when the Wahitohanga review began. With the exception of Ngāti Motunā through the plan review and Ngāti Rārere through the plan change 40, other iwi and hapu groups seem to have adopted the same approach as council, treating private landowners hosting SASMs as having no greater interest in those sites than members of the public generally. We draw the Commissioner's attention to Section 5.2.1, consultation with iwi and hapu, that's the section name, of the SASM Section 32 report, which provides an overview of the identification and verification processes being used to update and improve the accuracy of the SASMs identified in the district plan. It is an iwi hapu-led process and was meant to include pre-notification consultation with landowners. The report advises that the only iwi that completed pre-consultation with landowners, is Ngāti Motunā. Our understanding is that consultation process worked well and helped to foster and improve goodwill between tangata whenua and private landowners. The frustration is that leaves a number of other landowners and other sites that haven't yet benefited from any direct engagement or recognition of the important part hosts of these sites have to play. This context may explain why some SASM may be subject to ongoing degradation. The tangata whenua chapter of the operative plan includes a range of non-regulatory methods under Section 19.2. Specifically, it talks about encouraging landowners to protect sites on their properties through voluntary agreements and covenants, and to facilitate meetings and mediation between landowners and tangata whenua when appropriate. It also includes use of the Council's Heritage Protection Fund for the protection and maintenance of those sites, and financial assistance for fencing of sites of significance and areas. Rates relief is also included. In preparing for the SASM hearing topic, we're in the process of getting feedback from members with SASMs. We have asked if they were aware of these incentives and the financial assistance that could be tapped into to better protect or maintain these sites. To date, none have, and several have said that they often wondered about fencing off the sites, but hadn't been able to due to financial constraints. In considering the effectiveness of other methods, section 4.2 of that same section 32 report, it is noted that applications to the Heritage Protection Fund involving SASMs and archaeological sites are rare. No reasoning is provided as to why, but explicit reference to funding and rates relief has been pulled from the notified plan. We put it that lack of knowledge is most likely the reason for poor utilisation, and we suggest Council could do a much better job of prioritising and resourcing the non-regulatory methods. These methods are the exact things our members look for when any natural or cultural overlays are applied to their properties, and can be the difference between inadvertent loss and win-win outcomes. It is worth noting at section 5.2.3 that Ngā Kaitiaki sought retention of methods from the operative plan to apply to the historic heritage chapter of the draft plan, in particular the methods that promote protecting sensitive information, consultation, facilitating landowner iwi and hapu discussions, providing rates relief, and working toward access to wahi tapu on private property. Now, while the SASM P7 outlines some useful methods, the explicit rates relief and financial assistance through the Heritage Protection Fund are missing. Rates relief is not only missing from the proposed plan, but the option is gone from the rates remission policy. This policy was changed during the review of the long-term plan undertaken this year. Whilst the amended policy was consulted on, Council only sought specific feedback on changes that would be made to the natural areas component. The amendment to no longer provide rates remission on historic and cultural sites was not flagged at all. Further evidence that landowners hosting historic and cultural sites are not valued. The call to increase regulation to better protect sites seems to be suggesting all earthworks and cultivation should be subject to restricted discretionary consent status at least. We strongly oppose this relief as being unduly onerous and unreasonable in the context of farming and horticultural activities. We consider the notified response, which is appropriately nuanced and aligned with best practice, is appropriate. It must be remembered that permitted activities with associated standards is a regulatory tool, one that can get the balance right between resource use and protection of SASMs. This approach can be particularly effective when accompanied with meaningful non-regulatory methods that are prioritised by influential parties. In our view, if the non-regulatory methods were prioritised and utilised, the degree of degradation under the operative plan could have been much less. It is accepted that a regulatory approach is required to a certain degree, but it shouldn't be in isolation, and it shouldn't be the go-to if non-regulatory methods didn't work through no fault of the landowner. A balance needs to be struck between balancing the rights and interests of private landowners and tangata whenua. So we don't accept that the next and only option is to require consents for all earthworks, including cultivation. It is difficult for us to understand how Council and most iwi groups were not resourced enough to prioritise education and information sharing, or to help landowners utilise the Heritage Protection Fund to make a real difference on ground by fencing off or clearing exotic vegetation, and yet more onerous and stringent controls for landowners, which by virtue, and yet seek more onerous and stringent controls for landowners, which by virtue of consent application requirements will create more of a stretch on Council and iwi resources. This is counterintuitive to us and fails to take some responsibility for why the non-regulatory methods have not been well utilised or done their part to help achieve goals of the operative plan. We looked to the quality planning website on this topic just for some advice, and note from that website that regulation should be judiciously applied to create an appropriate balance between heritage values and the rights of property owners. Ideally, regulation should be counterbalanced with non-regulatory methods of management. I just want to talk briefly too about the scheduled and unscheduled sites. Now, we certainly appreciate the frustration that is felt when known sites have not been able to be scheduled due to not passing an evidential burden test. We have no knowledge or opinion as to whether the burden of proof is appropriate or not, but we do support the need to have one. It is appropriate to require an evidential burden when the planning response impacts on a private landowner's reasonable use of land. Without a two-tiered planning response, which includes appropriately set consent triggers, it elevates the effects of all earthworks and cultivation activities as being threatening to the integrity of all SASMs, a case which we don't think has been fully made yet. A subsequent risk to that approach is that if you treat everything as significant, it diminishes the value of the term. Now, to again reference the quality planning website, which we think supports kind of the position that we have, it states that as for any heritage site, as any heritage place, archaeological sites scheduled in district plans must be identified with geographical boundaries, which incorporate the need for buffer areas, a legal description and a statement of significance. Large lists of recorded archaeological sites with little ground truthing, analysis or justification should not be included in district plans. Accurate identification and statements of significance should be undertaken by a professional archaeologist. It also should include methods for archaeological site management in the plan in an appropriate form to match the level of information available. Where the information available is not detailed enough to prescribe regulation, use alternative methods to address RMA responsibilities. Such methods include non-statutory databases, mapping, and raising landowner awareness. So to conclude, we are seeking a planning framework that enables the ongoing operation and continued growth of New Plymouth's primary productive sector to the local, regional, and national food demands. There is a fundamental need to support the long-term growth of the district and to maximise the social, cultural, environmental, and economic values afforded by the industry. We do appreciate that much of the statement relates to matters which are perhaps more appropriately addressed in the SASM hearing topic. But for now, it may be best to summarise that we expect non-regulatory methods to be given as much priority as regulatory ones, that we consider it appropriate to require evidential burden for scheduled sites, given the more onerous land use controls which apply, and that the best planning response is to target controls against the effects or risks associated with the specifics of the site. The Hastings District Plan does provide an example of how well that can be done. We also hope that the accidental discovery protocol won't be over-relied on as a catch-all at the expense of relationship building. The effective protection of SASMs, both scheduled, unscheduled, and unknown, is dependent on the mutual goodwill of both private landowners and tangata whenua. With regards to the Earthworks chapter, we have not been able to get a clear understanding of what specific land use changes are being sought for either the general section or more specific parts of the plan. Without the specifics, our general concern is that submitters are looking to impose unreasonable restrictions, inconvenience, and cost on private landowners who may wish to undertake otherwise unexceptional farming activities. So that completes my sort of formalish bit. So happy to take questions.
Thank you very much, Hilary. You've been sitting in through the rest of the hearing pretty much, or?
So mainly Wednesday, I think, from memory, and a little bit on Monday.
Yeah, okay. Well, again, thanks for doing that, because it's certainly, your approach seems to be a lot about relationship building and better understanding, and I think having you sat in, and particularly on the tangata whenua submissions, is very useful in the round, I would have thought.
Yeah, well, that was the intention, to be honest. So we really want to get a good understanding of what the issues are.
Yes. So look, we've just received the statement. So I do have a few questions on the way through. Kit, I'm just thinking, are you prepared for some questions, or I'm happy to start either way.
Well, the only question I had, I found the answer to, and that was in paragraph 4, which was the reference to WBR4, and I realised it was a reference to the water bodies chapter. So I've picked that up, and then I didn't really have any other questions, Mr. Chair. I thought the statement was very helpful and raises some really good points, but I didn't have any specific questions of Hilary. No.
I do have a question about, you would have heard that there's been quite a focus from the other witnesses around EWP4
Yeah.
and the Accidental Discovery Protocol EWS5. So your position is that EWP4, as has been asked for by some of the other submitters, actually be deleted. That's right, isn't it?
Yeah, so well, our actual submission was supportive of P4, but through listening to the other submitters' concerns and turning my mind to it a little bit, I can see that it can create or may create unnecessary duplication and confusion. And I guess with the benefit of hindsight, really, and why I mentioned and went back through the Section 32 reasoning, it does seem to be out of step with the rest of the policies in the Earthworks chapter, which aren't specific and focused on, say, other Section 6 matters. So like I say, that is a movement. Our relief is around retaining it, but can certainly accept and see merit in perhaps relying on that SASM P5, I think it is. To be, if that makes sense.
So you've changed your position from what you saw in the further submission, is that right?
Oh, so that was in our written submission. I'd have to check what our further submission was. If we further submitted on P4, we may not have given, we had some scope with it, but I'd have to check. Our other further submissions related to the increased, or the calls for increased regulation, I guess. So they're more to do with the rules aspect.
Yes. So have you followed the discussion about SASM P4, which we had with Mr. Raymond from Heritage New Zealand this morning?
Yes.
And that was where he was concerned that that's prefaced by the word manage. Manage activities that occur on or adjacent to scheduled sites. So do you have any, you do have some submissions on the SASM chapter, I take it, and will be? Yeah,
we will do, yeah.
Yeah.
Sorry, again, I was really only looking at the rules kind of aspect of this, but I'm fairly sure we will. With regards to that chapter, so I'm not a planner.
Yes.
And given, it may be that we do put expert witnesses up for that particular topic, but we're still sort of working through, through the potentiality of that, and I guess waiting for the 42-hour report potentially. So yeah, so right now I don't have an opinion necessarily on the wording around that policy, if that's what you're asking me.
Yes, okay, no, that's fair. Probably a question for both you and Mr. Hooper, and I'll preface this question around the fact that in the scheduling of the hearings, we've ensured that the SASM chapters and the other historic heritage chapters come later in our process, so February, March next year, I think. And part of that thinking for scheduling was around the need for some further preparation work on some of those issues prior to us actually hearing them, because there are some big topics here. Would your opinion be, given the fact that there seems to be some relationship building with some hapu more so than others, that there could be some merit in some further coordinated discussions between federated farmers and the various hapu in between time, just to maybe get a better understanding, build some relationships, think about some combined, some approaches, particularly in the non-regulatory space, which might be able to be recognised?
Yeah, well, so I fully support that approach, but just to jump ahead of you, Mark, but I'll let Mark comment on that too, if you'd like.
Yeah, I would support that also. But I guess one of the other issues that we touched on there is around the verification of some of these sites, and that I think is a concern for a lot of landowners. Some sites, obviously, there's some kind of visual or physical evidence of their existence. Others are not much more than just a mark on the map, which may there may be some basis to, but there's no clear, you know, kind of physical on the ground evidence of something being there or having been there. So those kind of things need a slightly different approach to verify, to understand whether there is something of importance there. But certainly those areas where there is good physical visibility, there is an increased, you know, kind of awareness that I find amongst farmers to look after or preserve those sites, and those are the ones where there'd be opportunity for further discussion. It's worth noting also, you know, that cultivation has come up in this, which is interesting because cultivation was used historically, and I'm talking, you know, 50s, 60s, 70s, to break in a lot of this ground, and was used as a method to smooth out, as it were, some of these sites, you know, so that they were more able to be mown or whatever the case might be. But that kind of aspect of farming is long gone. You know, that's not a part of what happens on the ground nowadays. It's much different. So you know, cultivation takes place on high productive land with large machinery, and it's done on a regular basis. It's not used in that same technique of covering new ground as it perhaps once was in the past.
So that would have been in the day, you know, heavy tractors and bulldozers towing big discs, breaking land in the day. Yeah. Yep,
big disc plows, and often I guess that was on what we call relatively rolling or slopes as well. You know, that was part of the process of developing and breaking that land in, whereas nowadays cultivation is very much isolated, focused around either summer cropping here locally. There's not much winter cropping, so within easy access to dairy sheds because cows have an on-off grazing, or it's around maize, and maize using big harvesters and what have you is all done on flat land. So it's quite different to the kind of rolling country that was broken in back in the early days.
So look, I'm particularly interested in on this topic, Hilary's paragraphs 32 and 33, which is around this evidence of burden of proof and evidential tests. So I think we are going to be hearing evidence about some other sites which have been asked to come into the plan, for example, and there will perhaps be some evidence about some sites that are in the plan that perhaps might be arguable the other way as well. So I think, that's certainly something which we will deal with later in the hearings. You know, we'll take some advice from the council's 42A officers that will be looking at this issue later in the new year, 2022, whether around those matters there's any merit in some pre-hearing processes on some of these issues, and certainly that would need to involve tangata whenua as well. So I'm just thinking ahead about the time we've got in place to perhaps do some more work around the relationship, the understanding, some of these matters, particularly around evidence of or burden of proof and evidential tests, those sorts of things. Because I'm aware myself, sitting on hearings where there are archaeologists and tangata whenua involved, quite often the evidence isn't physical, it's either oral or there's maps that can be verified of sites and places, those sorts of things. So it's a mixture of both oral, written history and also what we can see on the ground. So it's quite a, it is quite a complicated area, which is worth, I think, keeping talking about. The reason I think this might be useful is I sat on the Christchurch City Council plan review processes a few years ago after the earthquake, and I was actually called to, I wasn't sitting on this particular Wahitapu sort of area, but I was called by the chair there to facilitate a 2 or 3 day session between the various parties about all these provisions, you know, right at the end of the process. And that was really useful, but I worked out that would have been really good to have done beforehand, just if there had been time, and we were under time pressure there. So yeah. Okay, well, it's useful to get that.
Sorry, can I just clarify what I said before, that I don't disagree with your point around some sites might not have physical evidence. That's, you know, that I've got no problem with that. But in terms of what we've been talking about is having, you know, a non-regulatory approach to managing some of these sites. If there is no physical evidence, then there needs to be that consultation process, because people might not understand that or be aware of it. It's fine that if the evidence is oral or whatever the case might be, but there needs to be a much greater understanding of that on farm if landowners are going to, you know, respond accordingly.
Okay, no, that's helpful. Well, thank you very much, Hilary and Mark, for your assistance. I don't have any further questions.
Right.
Thank you.
Thank you.
Right, Mr. Campbell, I think, for Kaingaora.
Good day, Mr. Chairman and Commissioner. Can you hear me okay?
Yes, you're loud and clear for me.
Thank you. I'll take my evidence as read, but just by way of background, my evidence is in relation to the Earthworks provisions, and it's a fairly discrete couple of points that I've raised. On the whole, Kaingaora has supported the approach of the plan in respect of Earthworks, and my evidence really focuses on a couple of areas, principally in relation to policy EWP3 and in relation to standard EWS2, and that's principally around the standard relating to earthworks associated with a building, and seeking to provide a little bit more clarity around what the effects are the standard are trying to manage. I've provided copies of the additional changes in my Appendix 1 of my evidence, and that officers' changes are noted in blue and my wordings change as noted in red text. Very short and sweet, but I'm sure you have questions and I'm happy to answer those.
Turn the speaker off. Kit, do you want to kick off this time?
All right. No, I thought your evidence was very straightforward. There's just two matters I wanted to talk to you about. One, your suggestion of qualifying retaining wall height based on whether it is either a cut retaining wall or a fill retaining wall. I'm just wondering, is that a technique you've seen used in other plans?
It's not. I mean, I have to say this approach is probably a little bit unique in terms of how it's dealing with earthworks. That being said, it is to a degree aligned with the former Waitakere City Council plan, which is now extinct, but that actually had a provision how that managed it was permitted within a building platform. So I think it's prudent to have a retaining wall height control if you're going to go down this approach. I think it's helpful to manage those effects. I was simply of the view that the effects of a cut retaining wall, particularly in relation to adjoining sites, is going to probably be less of an issue from an amenity or character perspective, as opposed to a fill retaining wall. And I was kind of thinking, to my mind, as you get closer and the relationship of the adjoining site, as you have a fill retaining wall, you have issues potentially of privacy, but you know, in the relationship with that adjoining property, whereas the cut retaining, it's not such a critical issue. And 1 meter is still it's not a particularly high retaining height. It's just, but it gives a little bit more flexibility to design properties without I guess being unnecessarily sort of restrictive. And it's also, I think, I kind of reflected on it in terms of the implications of a cut retaining and its relationship with an adjoining property, which may, for example, if it was a surrounding common boundary, have a fence, say 2 meters. So you kind of have a cumulative height of around 3 meters. And you know, that seemed to me to be a reasonable amenity outcome. As you go below that, you might want to kind of look at that. So it's very much about thinking about an appropriate trigger.
I mean, because thank you for that. I think the assumption is that if you're retaining a cut, you've done so because you've created a platform that you're going to stick something on in front of it, so that the wall to that extent becomes shielded by the structure you're putting onto the platform you've created. Whereas if you're doing a fill retaining wall, then you're obviously building the land up for a certain extent, so you're going to get a much higher structure overall. That's how I sort of graphically drew it. Yeah,
that's correct.
Okay.
Yep.
All right.
Yep.
The other question I want to talk to you about, and you haven't dealt with it directly in your evidence, but it's something that I just wanted to get your view on. Have you got the Earthworks rules there?
Yes, I do. Yeah, I thought I'd better get those up.
EWR 13 is one that when I went through the council's 32 analysis and then went through the 42A report, sort of stuck out to me as a rule that's using Earthworks to manage manage something else, because I got the sense that the concern here was that people might build roads and then ask the council to accept vesting of them without the council actually giving any sign off to that. And to control that, council have said, well, any road needs an earthworks permit, as that's sort of the trigger for them to actually come up with a view as to whether or not the road ought to go where the landowner wants to go. I mean, I'd be interested. Have you studied this rule at all? Has it sort of come across your?
If I'm honest, I haven't.
Okay.
I mean, it's kind of interesting insofar as if I kind of apply the practical examples. We're involved in lots of consents involving roads. I mean, in practical terms, you really want to engage with the local authority to get a degree of comfort that they're going to take the road on as an actual road before you kind of go down the pathway of consenting something.
Well, I mean, I would have thought that there are two other sort of things that control whether or not a road goes in a location that a landowner wants to put it. One is that presumably doing it in the context of a subdivision proposal. Yes. So there's going to be a subdivision scheme plan which identifies where the roads are going to go. And then secondly, council as the territorial authority has to sign off any plan prior to deposit where there's going to be a vesting of a road. So if you haven't got their approval in advance to where the road is going to go, and they subsequently then turn around and say, well, we don't want it in that location, then you've sort of shot yourself in the foot, haven't you?
Yeah, that's exactly right. Yeah.
So I mean, I guess, and it's something I'm going to bring up with staff as to why there's something about the earthworks associated with the road that make them any different from earthworks associated with land development generally. And if the issue is really about where the road goes, then perhaps that is better addressed in the location where that is going to occur, which is in the subdivision chapter, perhaps. And I just wanted to get your view as an experienced planner on that.
I'd be inclined to agree with you. Yeah, I'm struggling to see a reason why you would necessarily need to pull that out as its own discrete activity, because it would generally follow that it would either accompany a subdivision or an integrated consent for a combined land use and subdivision if it was a sort of a more intensive medium density housing project.
Okay. No, thanks for that.
Thank you.
No, I think that was all I wanted to ask you. Thanks for your help, Mr. Campbell.
Thank you, sir.
Michael, I did have one question about the interrelationship between EWP3 and EWR10. So I'm looking at your Appendix A.
Yes. Yep.
So I've gone back and had a look at EWP3. Now these policies relate to all earthworks activities across the district, don't they?
Yes, they do.
Yes. So your rider on number 2 relating to where that is necessary to manage effects on adjacent properties on or road reserves. Can you see other activities around the district that might not be housing related, where you'd have other reasons for managing cut and fill heights? I'm thinking about visual issues and very large cuts being made and stability and.
Potentially, but I think those are potentially covered by other aspects of the policy in terms of stability. I recall there's a policy that specifically deals with land stability issues.
Yes.
The only other thing that maybe comes to mind, it's a good point you raise, is adjacent properties, whether or not, quite often issues around public open space and retaining in relation to public open space. I mean, my wording says effects on adjacent properties, so it probably covers that. But quite often that's an important consideration, is the relationship of earthworks, particularly in relation to fill type retaining in relation to sort of open space areas.
Okay. There are some other rules and provisions about limiting cut height and fill heights that I think this policy related to. So I'm just thinking, and this will be something that the staff will obviously have a think about, whether the changes you're seeking has sort of a wider knock-on effect that perhaps might need to be thought about for some of the other rules in the plan.
Yeah, I guess I was just trying to make it the point that quite often there's good reasons, very good reasons why you want to actually encourage cutting, and so yeah, that's really it.
Yep, no, I get that. And the other change is really just ease of understanding.
Yes,
speed. Yes. Okay.
That's right.
All right. No, that's clear. Thank you very much for your evidence. Appreciate it as always.
Thank you, sir.
Thank you.
Thank you very much.
Just looking again for our schedule. Here we go. Right, Catherine, how are you? Catherine Hebblethwaite for Waka Kotahi.
Yes, morning, sir. Kath is just fine.
Yes.
And good morning, all other parties there. I'm assuming you have read my early evidence brief, and this morning I sent Julie a very short one-page summary, which effectively just confirms that my position or opinions expressed haven't changed. I can run you through that if you wish.
Yes, if you could, please.
Right, paragraph 1.1 confirms my full name is Catherine Linda Hebblethwaite, and I have prepared the primary evidence dated 6th of August. I'm an independent planning consultant with more than 25 years experience and have the qualification and experience outlined, and reaffirm that I have read and continue to abide the code of conduct for expert witnesses. The key points from my primary statement of evidence are in regard to earthworks. In my opinion, the area limit and zone-based consenting structure proposed by Ms. Lawrenson for transport networks does not reflect the likely effects or frequency of effects generated and poses an unnecessary regulatory burden. I continue to support EW7 as notified, which is one rule applying to all zones, but with an increase to the earthworks area to 2,500 square metres. For lighting, there is a small change to the overview section, which Waka Kotahi made a submission on, which I consider remains appropriate. For signage, there is only one matter which I wish to stress from my early evidence, is that Ms. Gibson very kindly invited Waka Kotahi to consider whether or not there would be alternatives available to AS NZS 4282. That is a standard which specifies lighting requirements. I have socialised alternatives to including that standard in the rules, which is what the Waka Kotahi submission sought, with Waka Kotahi staff members, and they are comfortable that Ms Gibson's and the notified provisions are actually suitable. There's no need to grant the relief sought by Waka Kotahi in that regard. So generally, the submissions made by Waka Kotahi, I've reviewed them in light of the Section 42 report, and the only outstanding matter is in regard to Earthworks. And I'd just like to confirm that Mr Catchpole remains online for Waka Kotahi. He doesn't have anything in particular prepared, but would of course be available to answer questions as I will do now, sir.
Thank you, Kath. I'm just trying to find EW7. You haven't got a markup at the back of your evidence, have you?
No, I have got the council planners provisions open on my other screen, sir. It is the Earthworks for the upgrade and maintenance and repair of the transport network. If it helps, sir, it's on page 7 of the council planners report in Appendix 1.
I'm looking at Appendix. So EW7, I'm looking at Appendix 1 of the officer's report. And that's the landscaped provisions with crossouts and insertions in it. That's right, isn't it?
Yes, sir, that's correct.
Yes.
Ms Lawrenson has proposed to effectively delete, it's a PDF page 7, so I'm not sure what numbering yours is.
Yes.
Would it help if I shared screen with the council planners Appendix 1?
Yeah, I've actually got the document here. So so you support retention of it as notified rather than the changes Ms Lawrenson's proposed?
Yes, that's correct, sir, except with the addition you'll see there in the second column along where it says activity status permitted, where the total, number 1, the total earthworks area open at one time does not exceed 500 square metres. I consider that should be 2,500, noting that this rule relates only to upgrade or maintenance or repair of transport networks, sir.
Okay. So just maybe for future reference, have you read our minute requesting that experts provide a track markup at the back of their evidence?
My apologies, sir, I may have overlooked that particular detail. I will definitely do that for future evidence.
Yeah, it was just after hearing 1 where I think Mr Campbell did provide a markup, and we found that particularly useful because we're looking for, particularly at the expert planners level, differences that sit between the council's planning team who are reporting on the application, or sorry, on the matters, and the submitters. And it has become a pattern now that all the experts are actually providing those for us. So that's why I'm trying to work my way around those. So perhaps that's something you could have a look at and just get to Ms Straka as just an addendum to your evidence, just
yes,
in that format, so we're crystal clear what you're asking for.
Yes, no problem, sir.
Yeah. So just by asking these questions and working my way through, I'll sort of understand that. So I don't have any further questions, but if you could add that into the system and also have a look about how others are doing it, and I'm sure we'll be hearing from you again in future hearings. That would be great.
Yes, sir.
Yeah. So thank you, Kath. That's all for me.
Hi. I've got the appendix open in front of me, so I just wanted to clarify the EWR7 originally applied to all zones and had a 500 square metre limit. Council recommended splitting it into 2 types of zones and giving 500 in one and 1500 in the other. So it's your you wish to retain the all zones application and 2,500 square meters across all zones. So it would come back to one rule, but with simply the 500 changed to 2,500.
Yes, correct. Yes.
Okay. Okay. All right. It's not a matter you've addressed in your evidence, but I'm going to take advantage of the fact that you presumably see plans up and down the country, and I want to talk to you a little bit about the way in which the matters of discretion have been crafted. I'm not sure if you were here on day one where I threw out into the universe a concern about the way in which the matters for discretion had been crafted with a suggestion that some of them, if not many of them, were phrased as assessment criteria as opposed to matters of discretion. And I just wanted to understand whether you were aware of that, and if you were, whether you had thought about it. And if the answer to both of those questions is yes, then what you might want to say about it. But if the answer to the first two questions is you have not, then we won't go any further.
Yes, sir, I was present on the opening day and did hear and take note of your question to the universe, as you've put it. I have had a brief look at it. Particularly, I went back to the Auckland Unitary Plan because that's a plan I'm extremely familiar with. I've also been dealing with the Whangarei and Far North plans and the Northland Regional Plan. I agree to some extent with your concern that the matters of discretion have somewhat of an assessment criteria flavour where they're related to the rules. I think that's less obvious where they are related to the, excuse me, I'm just scrolling down to the standards where they start on page 18 of the council staff members. They are much more matter of what I would expect to see as a matter of discretion. I think possibly unrelated to your question though is what I did notice as I looked more closely at the rule related matters of discretion is that they were quite repetitive, and it did seem that you could probably put them in one spot and simply have a cross-reference if the council was mindful to shorten up the plan, but that may be a much broader construct of the plan issue and not necessarily responding to a question either. But yes, I do agree that they are more assessment criteria worded. Whether that is a significant issue, I think you posed in your preliminary comments whether it was a significant planning issue, whether it was more a legal concern for decision makers. I think it's a fairly fine line. When you refer to the quality planning website, and that's a resource I also draw on, it's pretty clear about what it thinks assessment criteria should look like, and certainly some of the rule-related assessment criteria would tend to fall within that. So yes, so I think as an overview to that, for Waka Kotahi, it is a requiring authority and does have a designation in place for its transport network. So the level of detail you're looking at, whilst I've had a high level look at it, isn't something that is of a significant concern there.
Okay, all right. No, thanks. Thanks for your honesty. And I just remembered I forgot to ask Mr. Campbell the question, so don't go anywhere, Mr. Campbell. I'm going to ask the chair's leave to come back to you after we've finished with this witness, just to ask that same thing of you. The only other thing I was interested in was your suggested amendments to the overview and the lighting chapter, and it wasn't immediately clear to me where you were going there, but I subsequently pulled up your submission and I see the changes you've suggested there are relatively benign as I see it. So this is the amendment to the phrase, however, poorly designed, and you would say, and located artificial lighting can result in adverse effects. And then down in the last sentence, light spill and glare can also adversely affect traffic safety, the views of the night sky. That's what you're talking about there?
Yes, sir. If it's of assistance noting the chair's comments, I'll provide with my preferred wording on Earthworks, also the preferred wording on lighting. And again, my apologies for overlooking that part of the minute.
Yep, no, that's fine. I've worked that out. Okay, that's great. But thank you, Ms. Heberthwaite. I didn't have any other questions. Thank you, Mr. Chair.
Thank you.
Thank you very much, Kath. Would you like to speak to Mr. Campbell now before we break for lunch?
If he's there.
Yes.
Yeah. Mr. Campbell, you heard that. You heard the questions of Ms. Heberthwaite. Is this an issue you've reflected on at all? If not, that's fine. You don't have to have had. But I am trying to take advantage of the considered planning wisdom that's coming before us to see whether this is just a lawyer being pedantic in a world of planners, or whether there is a way that you think that this could cause confusion and there might be a better way of doing it.
Sir, I have to confess that I caught the end of that conversation as I was returning a call, but I'd be happy to, if you wanted to repeat that question, I have a think about that and try and respond. I think, am I assuming this is with respect to your comments at the opening of hearing 4 in relation to assessment criteria?
Yeah, just the way in which the matters of discretion have been crafted with varying degrees of evaluative direction that, in my sort of experience, might lead to confusion as to what it is that the discretion is actually restricted to, because it's encouraging an evaluation of an issue rather than identifying the matter that the discretion is restricted to.
Yes, I mean,
for example, where matters of discretion start with the extent to which or whether something. These are matters that invoke or provoke a question and an assessment process that don't necessarily specify what is the particular thing that is going to be the basis for which consent is refused or granted, and if granted, to construct conditions around. If it's not something you've turned your mind to, then don't do that. I'm more than happy for you to consider it, and we can perhaps talk to you about it another time.
I'm happy to do that, but I would just sort of make the comment as well that I think that approach is it's helpful too, and as I understand through most of the plan, having also the cross-reference to the relevant objectives and policies. So I think the two work sort of hand in glove. That it's helpful to go back to particularly the policies in terms of the reasons why the standard is in place and what the outcomes you're trying to achieve. It does become a little bit cyclical, and I know without wanting to sort of raise the unitary plan example, you kind of have that example in the unitary plan where you've got quite a few of the assessment criteria are simply driven by a reference back to the actual policies. And then in some cases, they have quite detailed assessment matters that include the wording, as you've suggested, the extent to which. And in some respects, it's a combination of both that's probably helpful.
I mean, to be clear to the staff who are listening, I don't have a problem with a plan having assessment criteria, even though they're not statutorily mandated in a sort of list, but they've become well accepted as another method or a provision of a plan that's relevant. And a lot of them are there to assist applicants and decision makers to drive their thinking around the matters to which discretion has been restricted. But in this plan, we don't have assessment criteria. They are all identified as matters of discretion. And I guess that's where I'm either just being pedantic or there is a potential issue here that I'm sort of getting ahead of to some extent.
I guess, to be honest, when I look at them, when I think of how you would administer them, I would reference them as assessment matters, assessment criteria, and maybe it's the terminology, but that's how I would look at it in terms of assessing an application.
But I mean, that's a very fair analysis and comment, but it sort of emphasises my point that if they are assessment criteria, then the plan has restricted discretionary activities without specified matters of discretion, which is a failing of a restricted discretionary rule. Yes. Anyway, look, I don't know if I can take it much further. Yeah, but thank you for entertaining me.
Thank you.
Thank you, Mr. Chair.
Thank you very much for that. We will take a break now, and I think let's come back at 1:15. Give people a bit more time to have a break and something to eat. So we'll see everyone back at 1:15. Thank you.
Good luck. Good luck. Good luck.
Hi, there you go. Good, good. Okay, yep. Right, okay.
Recording in progress.
Good afternoon, everyone. We're just returning to day 4 of hearing 4, and I will ask those that went on this morning when we kicked off today just to check in and say hello. I'm Stephen Daish. I'm the chair of the New Plymouth District Plan Review Hearings Committee, and I'm being assisted in this hearing by Commissioner Kit Littlejohn. So Kit's on your view there. Thank you, Kit. So perhaps those that didn't check in with us this morning, just quickly say who you are and we'll say hello. So I think Megan Barr, you're first on the screen.
Yes, kia ora, Megan Barr, representing the oil companies.
Thank you, Megan. Carolyn, you there?
Kia ora koutou, I'm Carolyn Rett, representing Transpower.
Thank you, Carolyn. Vance, are you there?
Yes, Stephen. Yes, Vance Hodgson for New Zealand Pork.
Okay. Hi, Vance. How are you going?
Good, thank you.
Have you got something, are you on today or are you just listening in?
No, just listening in if that's okay. We don't have any evidence. We were interested in hearing 4, but no evidence presented.
Of course, you're very welcome. Thank you, Vance.
Thank you.
Just trying to work out who hasn't checked in. I can see Marlene, you're there again today, just listening in.
Yeah, kia ora, it's Marlene from Te Runanga o Ngāti Muringa, just listening in, thank you.
Yeah, hi there. Jordan.
Afternoon, everyone. Jordan Landers from Horticulture New Zealand.
Thank you for joining us, Jordan. Is there anyone else new? I can see Gary Schofield from Powerco.
Oh, good afternoon, Gary Schofield, environmental planner from Powerco.
Hello,
and
Gary.
we've also got
Helen, who's presented some evidence. So I'll get Helen to introduce herself if she hasn't already.
Yeah. Thanks, Gary. I know your new boss very well, Mr. Kilty, who's arriving soon, I think, up your way. Is that right?
That's correct. Yep, starting next month, I believe. So exciting times.
Yeah, you've got a good one there. So you'll enjoy having him there, I think.
Great.
Thanks, Helen. Hello, how are you?
I'm good, thanks, Stephen. Hello, everyone. I'm Helen Anderson, so I'm a planner representing PowerCo.
Hello, welcome, Helen. And I think everyone else there are either on the staff team or they've talked to us before. So is there anyone I've missed just from an introduction? All right, I think you're tuned in with the protocol for these hearings. We are doing okay, but it's not easy to really focus over these Zoom hearings. The protocol is, as you're doing, if we're talking to you, please turn on your videos and your speakers. If you have any questions throughout the process and just want to say something, as I'd allow in a actually face-to-face position, I'd be happy to talk to people. So if you are needing to say something, turn your video on and your microphone and we'll have a chat. So I think we do have 4 or 5 people this afternoon. Again, I'll look at, just bring up the hearing schedule. Just bear with me, please. I don't know what we would have done with just one screen doing these. It would have been pretty difficult. But yes. Yeah, so we're kicking off this afternoon with Helen for PowerCo. So over to you.
Thanks, Stephen. So I would assume that the evidence that I've prepared has been read by the commissioners. So I guess at this stage, I would just here to answer any questions that the commissioners may have.
And you would have caught up with the fact that we do need to talk with, particularly where you're looking for some alterations over and above what the reporting planners have given us. It's quite important that we do ask some questions if we have them. So thanks for joining us. I do have a few questions, so I'll kick off this time.
Yep.
Look, and thank you for preparing the summary in your appendix as we've requested. That makes it quite helpful. But look, I think it's probably better to start by looking at your Appendix A, if you can perhaps turn to that. So we've been talking quite a lot about these policies, EWP3, P4 has been quite a subject for us with other submitters as well, Helen. But I'm just really to clarify, PowerCo is seeking the removal of EWP3. From what I've read,
yes, that's correct.
Largely on the basis that you think it's effectively a duplication of matters covered in EWP5. Is that a fair summary?
Yeah, I guess that is a fair summary. PowerCo is seeking that EWP3 be deleted. I guess the concern for us is that, or for PowerCo, is that the focus should really be on how the effects of the earthworks are managed and not what is to be controlled. So we, having considered the Section 42 officer's recommendation, which I think was making recommending no changes be made to EWP3 at all. PowerCo still considers that that policy should be deleted.
Because in your paragraph 4.15, you have a reason that that deletes the word minimise. Is that related to that?
Well, it is related to that policy. So what I've set out, or how I've set it out in the evidence, is to just kind of step through the rationale behind PowerCo's submission, and I guess the nature of the submission is first up that we recommend that it be deleted, but then I look at some of the other further submissions that were made by PowerCo in relation to EWP3 in terms of why perhaps aspects of that policy, if it were to be retained, aspects of the wording of that policy should be amended. But overall, PowerCo's position is that the policy should be deleted because it is adequately addressed by policy EWP5.
Okay. And look, I've done the exercise myself when I read your evidence to sort of match up the matters 1 to 7 with the matters 1 in EWP3 with those matters in EWP5. And I'd have to say I've found a pretty good corresponding matter, I suppose we want to call it that, in P5 as the topics in P3 cover. So, and I think, yes, I take your point there that there was some duplication. Do you think P5 is actually a stronger policy than the P3, given that P3 does have that minimise?
Well, I mean, P3, yeah, P3 has avoid or minimise currently, as it's worded, which is a pretty, could be a pretty difficult test to meet. And it lists 7 matters at the moment under that policy, which really, I guess, are tying through to the standards is the intent, I think, of the drafting at the moment. But EWP5 is more related to, I guess it's, in a way, it's a little bit more policy, written as a policy, whereas EWP3 is quite an effects and specific based policy in terms of how it's worded at the moment, which I think is that's the concern that PowerCo have, is that it lists, for example, referring to cut depth and fill height, it's listing quite specific matters which are dealt with quite adequately through the standards, and not really appropriate to be listed as part of a policy. And I think EWP5 adequately addresses the concerns that Earthworks might have within the region.
All right, and I think thanks for that answer. Again, looking at your 4.14 and 4.15, you seem to prefer the remedy or mitigate as opposed to minimise, and we have been asking some other planning practitioners throughout the hearing so far about their views on that, and the word minimise is used quite extensively through the proposed plan. So is your preference overall as a practitioner not to use the term minimise and instead use the remedy or mitigate?
Yeah, I mean, I guess, that if it is a term that has been used quite widely through this proposed plan. And that's not to say it's the right approach to take. I guess, yes, my preference as a practitioner is to have is to remedy or mitigate adverse effects rather than minimise. And I think because it can be quite difficult to minimise effects of work, and I guess the approach in terms of remedy or mitigate adverse effects, where practical, provides a greater degree of flexibility and ability to meet that particular policy.
So that the use of that other qualifier where practical, is that something you're suggesting be added? It's not, is it?
No, it's not. No.
Quite a few other submitters are suggesting.
Yeah,
that
I've noticed that in some of the further submissions. Yeah.
Yeah, and again, what's your view as a planner on those sorts of qualifiers?
They can be useful, I think, but it probably, you need to look at it as a whole in terms of whether you have other policies and the rule framework and standards in terms of whether it works adequately as a whole. So I think where practical can be a useful approach. I'm not suggesting that it be adopted here, but I think certainly instead of referencing minimise, to instead reference to remedy or mitigate at a minimum provides is actually a more appropriate approach to take.
Okay, thank you for that. And just one other, I'm dwelling on this paragraph quite a bit. You refer to the wording of the 42A reporting officer saying that they think retaining the policy as notified informs the effects standards. So that's not actually, the policy itself is not actually written into the effects standards, is it?
I think what they mean, that the officer means there, is that what the matters that have been listed, the seven matters that have been listed in P3 are then carried through to the specific standards. So for example, cut depth and fill height, there is a specific standard around, I think it's S, I'll just have to scroll down to it. S2, which is cut depth and fill height. So I think that's what they mean in terms of that policy then informs the standards.
Okay. Rather than being referred back to the policy in the standards. That's,
yeah.
I think that is a technique that some plans use, and certainly parts of this plan that I think it might be used as well as a technique. Yeah. Okay. Well, thank you for that. I'll move on to page 2 of your appendix, which deals with EWR 9. Here, this is on page 15 of your evidence in appendix A. You're suggesting here, I think, that we relocate the whole rule to the network utilities chapter. So can you just explain that a little bit more, that rationale?
Well, I think the rule itself relates to earthworks for network utility, so it's quite specific. And given there is a chapter specifically for and relating to network utilities, it just seems to be a sensible location for earthworks relating to network utilities to actually sit under the network utilities section of the plan.
Okay, so how you could, I presume, a rhetorical question, you could argue that for all sorts of different district-wide matters being put into different parts of the plan, I suppose, couldn't you? It's
well, I guess you could. Yeah.
Yeah.
Again, it depends on how you want the we want to have to look for various rules in a plan related to a particular activity, and I guess the rationale at the moment is that there is a specific network utilities chapter. If you're wanting to find out about, and this particular rule is specific to network utilities, so why not put it into the network utilities chapter, so that you're not having to look at a number of different sections of a plan in relation to a particular activity.
Yes, no, I certainly understand the rationale. I think it's a challenge that all plans have. You know, I know working for particular interest groups myself on plans, you're sort of looking for the easiest way of dealing with it from your perspective.
Yeah,
but,
exactly.
Yeah. Okay. I just wanted to understand what you're doing with EWR9, despite where it goes. You've got some other suggestions. So you're looking at taking out item 2. Why is that? Off the matters over which discretion is restricted.
Hold on. Sorry, I just have to get to the appropriate part of my evidence. Okay, so that was in support of, it was a further submission by PowerCo in support of a submission by Transpower to amend or delete some of the items under EWR9. And I guess, well, the rationale for supporting that submission by Transpower to delete item 2 because they are covered by other rules in the plan, and it just presented duplication. And I've set that out in paragraph 4.28 of my evidence.
Okay, I'll just make a note of that. Thanks, Helen. So you've double checked those other rules and you're satisfied that that's the case?
Yes.
I wonder whether you could actually just provide the nexus between taking this out and the other rules. What were the other rules you were particularly thinking about?
So it was items. So item 2, which is the extent to which land disturbance or earthworks will compromise archaeological sites, etc. Well, that's dealt with through the sites of significance to Maori.
Yes.
I can't quote you the exact rule for that. Item 5, well, that's just the extent of, well, that's not nothing specific. That's just a general catch-all.
Yes.
And the other one was 6. So yeah. So I guess the main one in relation to your question is just is item 2, which is the land disturbance or earthworks in terms of compromising archaeological sites or Maori heritage sites. Yeah. The other matters are, well, item 6 just relates referring back to policies. So that's a concern. I guess the concern there is that you're making reference back to, well, particularly EWP3, which is we've got concerns about.
Okay.
Anyway, yeah.
But remember, we did talk about that earlier on, about those policies appearing in standards. So
yeah. So at the moment it's sitting there as part of a matter of discretion against that rule.
Okay. And do you think that's perhaps the cross-reference has been done because the matters and the policies perhaps are issues that you might need to think about if you're actually looking at if you're not complying with permitted activity standards?
Well, yeah, I think that is correct. I guess the concern is just around the need to have EWP3 as a listed policy that you have must have discretion to.
Okay. And certainly the other changes on this page, you've added under the activity status compliance with EWS4 and EWS5. Now, those are control of silt and sediment. In S5, what was that covering?
S5 is the accidental discovery protocol. Yeah.
Okay. We've certainly had quite a lot of discussion about that.
Right.
During the hearing, and have you made specific submissions about that?
No, that was a further submission in support.
Okay.
Yeah.
Okay. In support of the protocol, or in support of putting?
And so I think well, I'd have to again just check my evidence, but off the top of my head, I think it was just in support of the addition to the rule of reference to compliance with EWS4 and EWS5.
Right, thank you. I'm moving to page 17 of your evidence, which is to do with EWS2, and this is the standard about cuts and fills. So we have had some other evidence about this, that if you're cutting and then filling back in again, you know, as long as the level's back as it was, you'll look thinking exemption for installation of underground network utilities is appropriate.
Yes.
Is that because, do you think that, or firstly, are cut and fill actually defined as such?
In the plan?
Yeah.
Good question. I'd have to have a look at the what was notified and just check that.
Yes, okay. But PowerCo, I presume, would have all sorts of different earthworks around different types of poles and facilities it was installing, whether they were transformer stations or the whole range of activities. So sometimes you'd be basically drilling a hole to put a pole in. Otherwise,
yeah.
Yep. And do you think that would be caught, digging a hole for putting a pole in by the cut and fill rules? I'm just trying to work out the practical reality of this for PowerCo.
Well, it could affect PowerCo in terms of putting a pole in, particularly if it had to go. You know, if there was something that had to be installed below a metre in depth, and that seems to be a bit onerous.
Yes, I thought there was a list of exemptions. Maybe that's for the noise chapter. Are there a list of exemptions for earthworks? John? No, it's noise. So you're looking at an exemption here in the standard to cover that matter.
Yeah, that's correct. So what we're looking at is just adding to EWS2 that standard doesn't apply to the installation of underground network utilities where that cut and fill doesn't change the ground level once that work's completed.
Yeah, I can understand the practical aspect of that for sure. All right, well, look, those are all the questions I have. And you also had something on light, I think, is that right?
On lighting? No,
wait on.
No, just noise, just the noise.
Oh, noise was the next one.
Yep.
All right, so you did have one part of the noise provisions where, this is
Yes.
where you were seeking the exception. That's where I've.
Yes, that's correct. Yep.
Okay. Yeah, I did have a question about the specificity of that exception. The term normal operations in gas delivery infrastructure. Just in your mind, how would you interpret normal operations? Would that include that operations wouldn't include construction activities? Is that how you read that?
No, this is for infrastructure that's in place. I guess, yeah, so I guess PowerCo's concern with this particular noise S1 rule is where there's already, where there's infrastructure in place, where there's that potential to have that reverse kind of sensitivity, particularly where new development might be occurring and there's already gas infrastructure there, and where there's a need for that infrastructure to be there, and then you might get new residential development coming in next to this existing infrastructure, and then you start getting noise complaints about it. So that I guess kind of forms the concern that PowerCo have just around the noise standards in general, and the approach that we're proposing is that the gas infrastructure be listed as part of the exemptions to the noise standards at the beginning of that chapter.
Yes, I can see that. Are the natural gas operations inherently noisy? Are they?
That's something I'd probably have to defer to Gary Schofield on. I'm not sure what the level of noise is that is generated by gas infrastructure. I imagine some of it's not that noisy, and other activities may be a bit noisier.
Well, Mr. Schofield, if you're there and you could help us with that, because I think Mr. Lloyd's saying, well, if you can comply with the same noise standards as everyone else needs to, why do you need an exception? But we just need to understand the reasons why.
Yeah, certainly. And the level of noise isn't that great from our infrastructure. If you can imagine, when you've got your gas bottle going at home, you can hear the flow of gas, like sort of like a hissing pressure, that noise just flowing through that regulator. It's just on a larger sort of scale. I've been with it. So these are district regulator stations, so we take high pressure gas and just drop it down on that pressure to deliver throughout our network. So it's like your gas regulator on your barbecue, but a bigger scale. I've been inside them. I can walk around without air protection on, so it's not that noisy that you'd need it. But I guess it's the concern we're having was just with that a sensitive use coming or establishing adjoining one of our sites. And if you're used to a quiet environment and hear this noise, which is sort of ongoing 24/7 with the supply of natural gas, just for that potential for complaints to be generated. So it's definitely not exceptionally noisy. Yeah, you can walk around and have a conversation with it going there, but it's just that constant noise which some receptors may be sensitive to.
Gary, have you had issues with complaints?
Not to date, as far as I'm aware.
Okay. Thank you. Well, thank you again, Helen, and for Gary and Co for coming on. I'll hand over to Commissioner Littlejohn to see whether he has any questions.
Thank you for that, Ms. Anderson. I just really wanted to touch on the last point that the chair raised, because I was confused as to the basis for the need for the exclusion from the noise rules, because there wasn't any other evidence filed of a technical nature. So yeah, I'm grateful for Mr. Schofield's comments, but I'm wondering though whether we do need something slightly more than that in order to exempt PowerCo from any noise rules, when the thing that's been identified of concern is really around reverse sensitivity rather than you're really noisy and you need to be you need to be excluded. I mean, if you can comply with the noise rules, then no amount of complaint from a neighbour can really change that, can it?
No. If you comply, you comply, and even if there are complaints, yeah, there's really, I guess it's more of a reputational issue for the company rather than anything that the council could do as an abatement process.
So there's no evidence that PowerCos or the natural gas infrastructure can't comply with the effects noise standards, is there?
No, we haven't got evidence to present to you on that basis, no.
So I can assume from that you can comply with all of those noise limits, can I?
Well, without having had some technical work undertaken to go and measure outside some of these gas distribution facilities, I wouldn't be able to. I wouldn't be able to answer that question.
Right. Okay, no, that's okay then. That was the noise one, and I think the chair covered all of the things that I was going to ask you about in the Earthworks run. Yes, I think you have an ally with Transpower making a similar suggestion about moving the specific network utilities Earthworks roll back up into the network utilities chapter. So you're not alone there, although I see from the suggestions I think Ms. Ratt has put forward, it's a slightly more comprehensive shift in terms of moving up into the network utilities chapter, bringing in place some of the other standards around the instability and the accidental discovery protocol. So you might want to just have a look over Caroline's evidence. I think it is Caroline. Yes, because it's a similar sort of concept. I mean, do you put everything around Earthworks in the Earthworks chapter, or do you put everything around network utilities in the network utilities chapter? And I don't think there's a right answer. I think we've just got to look at it from what's going to be the most effective way to deal with it. Is it the activity or the person doing the activity that you sort of organize things around? So but that's something we'll talk about in due course amongst ourselves at the panel. But no, I understand the rationale for those changes, and yeah, and that was it. I didn't have anything further. So thank you for making yourself available. Thank you for your evidence.
Thank you.
And thank you very much, Helen, and we'll might see you again from some of the other chapters.
You may do, I suspect.
Yeah.
Okay. Thank you, Stephen.
Okay. Right. Jordan, it's your turn now, I think.
Well, good afternoon, commissioners. My name is Jordan Landers. I'm an environmental policy advisor at HNZ, based here in Wellington, but originally from Taranaki, so I know the area quite well. I'm happy to start off just a quick kind of recap of our position statement, and then hand it over for any questions if that sounds like a good approach.
Just hold there, Jordan. I need to find your evidence. Just a minute. I don't think I've printed it off. I'll just get it up online. Just stand by.
Mhm.
Here we go. Thank you very much.
Cool. So my statement focuses mostly on the Earthworks provisions and the noise domain. We accept the 42A changes, so I'll just focus on the Earthworks topic, where for the most part we do support the approach to the plan and the recommendations of the section 42A author, and just touch on kind of two refinements, so to speak, with respect to the Earthworks rules, which relate to ancillary rural earthworks and providing for biosecurity response. So what Hortensia's submission sought was a specific activity, defined activity for ancillary rural earthworks, and then a specific rule addressing that activity. And in the statement, kind of refine that a bit more to an amendment to E11, which touches on some of those kind of rural, what I would consider business as usual type activities, to just widen it a little bit to a bit of a broader scope of rural ancillary earthworks. The reason for that being that otherwise there's other activities such as farm drains, erosion sediment controls and the like fall to E12, which then come with a volume standard. So that's kind of the rationale of the change that we're seeking there. And the second part of my statement just discusses an amendment we're seeking around biosecurity provisions and rules for response to that. So I believe the section 42A author does recommend putting a mention of that in the policy framework, which we support, and we're just seeking that that be carried through into a permitted activity rule specifically. Again, the activity would otherwise fall to 12, I think it is, and that one is subject to the cut depth restrictions, which could be a limitation for the activity in regard to burial of plant material that is infected in a biosecurity incident. So that is the kind of overview of the two changes that we were seeking from the section 42A. So I will hand over there to any questions.
Thank you, Jordan. I have marked your evidence up. I just can't see it amongst my pile. So I'll hand over to Commissioner Littlejohn to kick off. He's got everything, and I'll have another search. Just stand by.
I'm just tracking down, making myself familiar with your means, your ancillary rural earthworks definition. You've got cultivation, harvesting, farm tracks, silage pits. Okay, so going back then, your paragraph, sorry, how rude of me. Hello. You just get so used to everyone being online all of the time. It's like, yeah. So thank you for coming along.
No problem.
Paragraph 16, your last bullet point there, you've helpfully gone through and identified what's in and what's out of the various rules, and you've got to you sort of conclude down the bottom last bullet point that there are a number of things that are unaccounted for and would therefore fall within EWR12. And so just so I can clarify, your inclusion of ancillary rural earthworks would therefore effectively account for those things so that they would then be excluded from Earthworks Rule 12?
Yes, that's correct. So then, yeah, they would come under what was previously just limited silage pits and vehicle tracks, which is still subject to the kind of general suite of effects standards, but compared to Earthworks Rule 12 that has additional volume controls as well. So that's kind of the distinction.
Okay, that's where I was getting confused. Okay. Sorry, that's noise, Earthworks. Ah, yes, okay. Yep, okay, all right, no, that makes sense, thank you. And I think that was the only thing I wanted some clarification on, but yeah, no, okay, very clear and understood, thank you.
Thanks.
Okay, I do have a couple of questions. One is about the ancillary earthworks rule. Did you, I haven't gone back and double checked, sorry, but was that requested as part of the original submission or as a further submission?
So if my recollection is correct, I think that we sought a permitted rule for ancillary rural earthworks and then also submitted on the Earthworks R11 kind of supporting the rule, but any consequential changes in respect of the ancillary rural earthworks. So yeah, it was in our original submission.
Yeah, were the actual words in your definition as per requested?
The definition of ancillary rural
Yes.
earthworks.
Yes.
Yes, I'm pretty sure that was in our submission.
Okay. I'm not saying it wasn't, I just haven't double checked. I just wanted to check. Are you aware whether there were further submissions for or against that?
I think there was a submission in support from Federated Farmers and a handful of submissions opposing, I believe. I don't have the names of the parties to mind, but yeah, I think there was a few further submissions on those points.
Yes, but that hasn't been supported in the officer's report after thinking that through from their perspective, has it?
Correct, yeah.
Yes, okay. And I think Earthworks itself has a definition that's in the National Planning Standard, so perhaps that's part of it as well. But I can certainly see what the issues are that you've put in front of us, so that's helpful. Will you be appearing on other matters or presenting evidence, Jordan, through the rest of the plan?
Possibly in relation to the rural topics, which I know are a bit later on, I think next year.
They are, yeah.
Yeah.
So when we issued a minute at this reasonably near the start about tracking in changes over the top of the recommendations from the 42A officers. So perhaps what you've done, there wasn't any. Oh, have you noted the changes in?
Yes, I
Appendix
believe
2.
that I've done them in the right at the back.
Right at the back, I've got that. Yes.
Yeah, Appendix 2 to my
Appendix
statement.
2. Okay. Yes.
And I think I've just pulled out the provisions of relevance to what I was talking about, and I don't think there were any. Oh yeah, sorry. There's one change from the section 42, which is just in the black highlighting.
Yeah, I can see that there now. No, that's great. Thank you for doing that. One last question, Jordan, about the Biosecurity Act. Does that deal with both plants and animals, or is that just a plant-based? I'm thinking, does this relate to stock that might be in a biosecurity problem, or is it just the plant issues?
That's a good question. I guess being horticulture, I only really have thought about it in the plant aspect. But I think that the Biosecurity Act is so broad as to cover animals as well, but I would have to confirm that. But I'm not familiar with a different act that covers them, so I assume it's in. Yeah.
Yes. So this is normally in the, we've got some state of some problem, emergency, there's been an outbreak of something, and material needs to be buried as part of the response. That's the general premise.
Yes, yeah, and I think the most kind of prominent example, which kind of brought this to front of mind in terms of Port NZ's policy work, was the PSA outbreak, which affected kiwifruit. And in that situation, kind of the recommended approach was to either, for the removed material, bury it on site or burn it. So that's kind of where this the need for these provisions came from our perspective.
So it seems quite a practical element. I certainly understand that. So yes, so thank you very much, and thank you for joining us. We have no further questions.
Cool. Thank you very much.
Thank you. Carolyn, I think you're next, is that right? Oh no, Megan Barr. Megan, are you there?
Yes, I am. Sorry.
Right.
There we go. Good afternoon, Commissioners. Thank you for the opportunity to answer questions. I submitted a hearing statement with evidence and would be happy to talk through anything that you have questions on.
Yes, okay, I'll just find your statement, just hold there. What, do you want to start with signs or earthworks?
Earthworks, please.
Okay. I'll get the earthworks one. Okay. So do you just want to, there are some matters in here that you have identified as being accepting of the council planner's position?
Yes, that's right. So on the majority of the earthworks provisions, we're in support of the section 42A recommendations. There's just two outstanding issues of concern for the oil companies, being EWP3 and EWS2.
Yes. So were you listening before when we heard PowerCo suggesting that P3 could perhaps, or should perhaps be deleted?
Yes, yeah. So
turn your mind to that as a practitioner and follow the discussion?
Yes. So on that front, we would very much concur with PowerCo's conclusions around that, in that it duplicates a lot of the matters addressed by P5, and that the specificity of the provisions in P3 is drafted more like a standard than a traditional policy. So yeah, if the relief sought by PowerCo were to be granted in this instance, that would address the oil company's concerns as well. If it's not granted, then we retain concerns around the use of the term minimise as being quite subjective, difficult to establish or prove, and overly restrictive.
So in your practice, Megan, do you see the term minimise being more restrictive than remedy or mitigate?
I think remedy or mitigate gives you more options, whereas minimise, as I think I've said in my evidence, our concern is that using the term minimise can be interpreted as requiring all possible measures to be taken to reduce effects to the smallest possible extent, and that they may not be necessary or practicable in all situations, and represents a higher threshold than the mitigation of adverse effects. So given that the objective provides for the mitigation of adverse effects, it would seem inappropriate for the policy to then require a higher threshold.
All right, so you're linking it back to the way the objectives framed.
Yes, and to retain that option of remedying or mitigating where the requirement to minimise would be impractical or result in considerable time delays or cost to prove that you have gone to all possible measures to minimise.
All right, so I understand that. Your changes to EWP3, the alternative option, this is where we're perhaps looking to detune some of the wording on the counterfactual or the opposite way.
Yes, so that again relates back to the terminology requiring the very highest threshold of minimisation. So we consider the use of the word minimise in conjunction with the words restricting and limiting as problematic. It would sort of lead to the interpretation potentially that by restricting and limiting earthworks as far as possible to minimise effects, you would de facto be required to adhere to the standards or make it very difficult to do any work that was significantly greater than the standards provide for.
Would you accept that a term like manage has got the same problems as minimise?
No, so from my perspective, management takes you back to the objective of avoiding, remedying or mitigating. So where you are doing earthworks that might trigger a standard, if you can put a thorough construction management plan in, and you can put in mitigation and remedying factors, you may be able to bring that down to an acceptable level, whereas restricting, limiting and minimising is very very strong language around something that you could achieve a good environmental outcome without restricting, limiting or minimising.
But the plan does have rules and standards that are restricting and limiting cut depth and fill to the maximum volumes, isn't it? So these...
Yes, that's right. So again, it's because there is the presence of those standards, it's the need for this policy to be sort of duplicating the standards or being more like a standard in itself than a policy.
Right. Okay. Thank you. And I see your note there that you would have heard from Ms. Anderson that we're talking about the finished level of land rather than being the. So you're looking at the same issue in a different way.
We are. So yeah, that was our concern with EWS2. So we were coming at it with notes as opposed to the particular provision that Ms. Anderson was looking at, but with the same concern that when you have a cut and backfill operation that returns the ground to the existing levels and contours, there's no ongoing effect of that particular operation.
Right, I understand that. Is your preference for advice notes and standards, or to actually try and work within the wording itself?
So there was, we gave two alternative options. Our original suggestion from our submission was that the note be added to EWS2, but we were equally happy for the exclusion to be added to EWR1.
Okay, so you're given those two options, which again, I've said to other planners, it's really helpful when you are thinking about different ways of skinning the cat. So thank you for doing that. All right, on earthworks, I don't have any other questions. So Commissioner Littlejohn may have some.
I did not on earthworks. That was all very clear. Thank you for the track changes. I understand the position.
Great, thank you.
So then, did you have any thing you want to talk about with signs, Stephen, or did I miss the signs? No, okay. I'm still trying to get my head around the change you're seeking there. Can you take me to the place where that is most easily identified?
Let's see. So probably in attachment 1. Yeah, so basically what we were seeking was that sign S9 be deleted in its entirety on a number of grounds, which I talked through in my evidence, but basically it is accepted that it is within Waka Kotahi's guidance. However, we don't see bringing it into statutory regulation as being necessary or practical, certainly not in terms of the restrictions it would place on signage within town centres and and even neighbourhood areas where you have existing petrol stations. Quite often the 50-metre separation distance is going to encompass potentially 3 or 4 properties in terms of frontage, and that could be a serious hindrance, not just to replacing existing signs, but to new tenants of properties looking at putting up signage.
Okay. I'm still trying to find, I understand your preferred option is get rid of it. In terms of your alternative option, how is that different from councils? Maybe am I missing something?
So I think we have added in the all zones, we've added more exclusions. So if you see the underlined in under sign S9,
large format retail, mixed use, town centre, city centre, and general industrial.
Yes. So the places that you would typically find petrol stations.
They're the same though.
They're the same as the council's list.
As the council's
That's all.
version.
I think that they may not have been the same as the councils. They certainly do look it. Yeah.
Okay, I'll just go back to the original version, which it's sign R.
Sign S9.
Sign S9.
Sign S9. And it's table, what's the table that? Oh, we've got there, table 10.
Yes.
Table 10. Sign S9 was originally all zones.
Yes, so I think that's an unintentional error in my attachment. Apologies.
Okay, but I see the difference with the originally notified table 10. It did not have the speed bracket 0 to 50 and 50 meters. So if I just then look at the,
I think the original went from 0 to 70.
The original is 0 to 70. It was 60 meters.
Yes.
And so what council did in the 42A report, getting there, sign S9, R9, S9, P9, O9, goodness. Yeah, they've added in 0 to 50 and 50 meters. Okay.
Yes.
So is your alternative option to accept council's section 42A report revision?
No, so we're wanting to, the alternative option is to add those zones, because I believe council to add the exception of those zones.
All right, now I get it. So what you're doing is excluding from the minimum setback distances signs within those zones. All right, yes. I guess okay.
Where the error is, Megan, is in your preferred option. That should just say all zones.
It should, yes. Yeah. Apologies for that.
What, sorry.
Yeah.
Just goes to show I'm easily confused. There you go. All right.
Yeah.
So, okay, so rather than delete the whole rule, your other option would be to exclude those zones where you might be likely to find a need for signs with less separation distance than 50 meters. All right.
Yes, yeah, just because there are numerous businesses located adjacent to one another and the site frontages are comparatively narrow. And signage is an anticipated element of such business and commercial activities. So it's unrealistic to expect only one sign in a 50 meters distance in those environments.
Yeah, I guess essentially, if you're on an already heavily signed thoroughfare, you've got to effectively look for 100 lineal meter gap with no signs in it in order to put your sign up as a permitted activity. Otherwise, in any other case, if there are already existing signs there, you're always going to need another consent, aren't you?
That's right. And like Jordan, I grew up in New Plymouth, so I just thinking about places like the one-way system, where you come past Countdown and Pack and Save, and you have a lot of businesses in really close proximity.
Okay. No, thank you. That makes sense now. Understood. Thank you for that.
It's similar. It's a similar issue that what Mr.
Ellerton raised as well, wasn't it? Anecdote, yeah.
In town centres where you've got separation of 50 metres between signs, and you might have a building with lots of different tenants in it that want to hang a sign. So it's a similar principle, I think. So
that's right. Yeah. It's just practicality and whether it's a sort of unintended consequence of this that you might end up with a lot of resource consents being required for things that aren't actually having huge environmental effects that need to be managed via a resource consent.
All right. So thank you for that clarification. And thank you again for joining us. We may see you again through the process.
Yes. Thank you so much for your time.
Thank you. Now we're with you, Carolyn, I think.
Thank you. Now I'm in your hands as to how you'd like me to proceed, because I have prepared a summary of evidence in accordance with your directions. So if you'd like me to run through that, because I understand you probably wouldn't have had time to read it, or if you'd just like to ask questions, entirely over to you.
Why don't you just give us a quick run through? Did you send that through to Julia this morning, or?
Yeah, but I'm happy to screen share if that makes life easier.
Yeah, why don't you do that? That'd be good.
Sure, no problem at all. So just checking that that's come up.
Yes, we can see that.
Brilliant. Okay. So the introduction really, and I won't obviously read this verbatim, but the introduction just draws your attention to, in terms of TransPower, the National Environmental Standard for Electricity Transmission Activities does cover a lot of their earthworks for the existing structures and lines that were in place before 2010. But so TransPower's interest in earthworks is really within the National Grid Yard, and this we covered in the Network Utilities hearing. But in terms of this particular hearing, it's any earthworks that's undertaken as part of their activities that have been post 2010. So going down to the first one, and I've just made this just summarised basically my evidence. It hasn't elaborated on it, it's really just summarised it. So the first one is the location of the earthworks provisions for network utilities in the plan, and I did hear you talking to Ms. Anderson earlier in regards to PowerCo. So I've looked, when I was thinking about how to approach this, I looked at the National Planning Standards, and I agree it's not particularly clear, but the way it was worded made me think that, you know, whether these particular provisions go in the Network Utilities chapter or in the Earthworks chapter, the way it was actually worded in the standards made me think that the energy, infrastructure and transport section was the priority. And so I've as you've noted earlier, I've taken a more holistic approach to relocating those provisions and taken the appropriate, well, what I think is the relevant standards and the policy with them to make it more of a package. I don't consider that relocating these provisions into the Network Utilities chapter undermines the integrity of the district plan. And I think in actual fact, it will make it easier to implement with all the Network Utilities provisions in one place, both for the Network Utilities operators, but also for council administering the plan. And so when considering a consent application for earthworks associated with network utilities, such as a discretionary activity, there's nothing to prevent the objectives and policies in other chapters like the earthworks chapter from guiding the evaluation of the application, despite the rules being located in another chapter. So I don't think that by splitting them, it, as I said, undermines the integrity of the plan. Going down to section 2.2, description of the activities. I do support the inclusion of the words including earthworks for ancillary activities at the end of rule EWR9 to capture the scenario where earthworks are required that are not a network utility operation per se, but they are associated with a network utility and undertaken by a network utility operator. And I thought when I looked at this issue, what was the risk to council? What was the risk to the district plan? But given that the scale of earthworks is quite limited by the standards, I see little risk in including those words. And I think that was a submission going off memory here that was sought by Kotahi. Moving down to section 2.3, so earthworks standards for network utilities. I've had a look, the original submission from Transpower challenged all of the standards, and I've looked a bit more closely given the comments of the section 42A author. The one I considered that might still be a problem is standard EWS2. And I know that you guys are already aware of that. I've listened to your comments with regards to Ms. Anderson for PowerCo. To my mind, the standard establishes cut depth or fill height based on the building setbacks for the zone, but network utilities often span a very large number of sites, and underground network utilities will most definitely cross site boundaries. Compliance with the standard to me seems inappropriate for network utilities, particularly underground network utilities, which, as I've said, the site boundaries and the underlying zones are somewhat irrelevant. So I'm concerned that the standard will unintentionally apply to earthworks associated with underground infrastructure, even though the profile, contour and height may remain the same. And the problem is that the maximum cut or fill is 0.5 metres inside the minimum building setback for the underlying zone, and 1.5 metres outside the building setbacks is not limited in its application to the final profile. And my concern is that this could unintentionally capture a cut and subsequent fill to install an underground network utility, for example. So as a solution to that, I support either removing compliance with the standard for underground network utilities or clarifying that the standard only applies to the finished land profile. And I listened to your questions regarding, was there any definition of cut or fill in the plan? To my best of my knowledge, there isn't, but what I am interested in is the national planning standards in terms of earthworks. Just the way it's written is around earth disturbance. So it can be cut, it can be fill. There isn't, I guess, those are terms that are kind of widely accepted. Maybe there is no need to actually define them. Moving on to paragraph 2.4. So this is matters of discretion for network utilities. So I have concerns about matter of discretion 2 for rule EWR9, which relates to archaeological sites, areas of significance to Māori and historic heritage. Given the structure of the plan, which complies with the national planning standards, I do not see the value of this matter of discretion in the earthworks chapter, as any site that is an archaeological site, significant area of significance to Māori, or a historic heritage site will be addressed under those respective chapters. Policy EWP4 is largely not relevant either. The only clause that I consider relevant is regarding accidental discovery protocol, but this, I know that's already contained in policy EWP37. Although I understand that this is a plan-wide issue, I really do have difficulty with the concept of using policies as matters of discretion. I think mostly, particularly in the way they're drafted, is they don't lend themselves to